Good morning, Judge Cohen. Are you comfortable?
I am, yes.
Okay. Are you well?
I am. How are you?
I'm fine, thanks. You were here, well, not here, but in a similar venue in front of this body for another position not so long ago.
That's correct.
I take it that you are familiar with the process.
I am, thank you.
And don't worry, we'll be gentle with you. You hold 3 law degrees, a BA and LLB from UCT and ABCL from Oxford.
That's correct.
You joined the bar in 2001 and remained there for 20 years.
That's correct, yes.
And by the time you left, you had been conferred with the status of silk.
Yes.
When was that?
I think it was in 2018. I think I was recommended in 2017 and status was conferred in 2018.
All right. And how long did you practice as silk?
It was only for about 2.5 years, I think, before I was elevated.
All right. You became a judge in 2022.
Yes, with effect from 1st January 2022.
In the Land Claims Court.
Yes, I was appointed a judge of the Gauteng High Court.
Oh,
and
yes.
then seconded to
the
what was then the Land Claims Court, yes.
All right.
And so now I hold a position as a judge of both courts. I'm a judge of the Gauteng High Court and I'm a judge of the Land Court by operation of law.
All right. You are currently acting as, in which position in the Land Court? Let's hear you in your own words.
Well, I'm currently serving a stint as the acting Deputy Judge President of the Land Court. I was appointed in that post with effect from the 22nd of May, and the stint lasts until the end of this month or until this body appoints someone permanently.
Yes.
Yes.
All right. I want you to tell us the challenges you have identified in that court. We know there are many in all courts, in fact, and how you plan to assist the Judge President in addressing them.
Yes, thank you very much, Chief Justice. I mean, as you say, the Land Court faces many challenges. And I'd like to preface my remarks by making 2 high-level comments. The first you've already touched upon, which is that that procedurally, it seems to me that it's very important that the vision that we adopt as a court is one...
I'm sorry, I'm hard of hearing, and
are you struggling to hear me?
The recording equipment here is not the best. Would you just pull the mic closer to you?
Yes. Is that better?
Yes.
All right. I want to start by making 2 high-level points, one of which, Chief Justice, you've already alluded to, which is that, as I see it, the approach to our challenges does need to be led by our Judge President. And we have a new Judge President of the court who started on the 1st of June, hit the ground running, and is already starting to frame how we approach our challenges. So I think her leadership in how we frame it is important. And procedurally, I also think that it's very important that we adopt a consultative approach. We have a lot of stakeholders who are profoundly affected by land matters that reach right into rural areas. And it's critical, as I see it, that we hear their voices in how we frame our responses to the challenges that we have. The second high-level point I'd make is that I do think that we need to think quite ambitiously about this court and what we plan to, what we hope to achieve with it. Our fundamental task is to implement the vision of Parliament in enacting the Land Court Act. And its vision, Parliament's vision, is very ambitious. It recognizes that there's been far too slow a pace in the land reform space, and that we haven't achieved land justice in this country. And it recognizes that the importance of having a court that is well-resourced, efficiently run, and able to deliver on those promises, which are the Constitution's promises. So we need to think, I believe, very ambitiously about how we go about meeting our challenges. Because if we don't, there's just too much at stake in this space. So against that background, let me identify sorry, I turned off my microphone. Let me just identify a few themes that I think frame the challenges and at this stage, and I can always speak in more detail to those that the commissioners may wish to follow up on. So we have a real need to strengthen both the judicial and the staff component of the court. We don't have enough judges, and we don't have enough staff to deliver on our mandate. I believe we need to prioritize clearing the restitution and the labour tenancy backlog. Parliament will be fully aware of those statistics, both in context of both labour tenancy and restitution. We're looking at very serious backlogs that are affecting rural people in very profound ways, and people are understandably very frustrated and angry about those delays, and we need to clear those backlogs. Nonetheless, I believe we need simultaneously to position ourselves to embrace our expanded jurisdiction. As I think most commissioners will know, that the expanded jurisdiction of the Land Court is quite ambitious. And I believe, I won't mention the acts at this stage, but what it does do is it brings us squarely into a space where we're not only going to be dealing with restitution and ESTER and labour tenancy, but embracing the idea of redistribution, I think, more fully in our court. And it gives us, I think, a greater ability to meet the broader challenges of land justice that this country is facing, and we need to embrace that fully. And that's a real challenge, and we need to prepare ourselves for that. Then turning to the more practical, I would suggest that we currently have a unique opportunity to introduce the digital court system that JP Mlambo has piloted in Gauteng. Now, the Land Court went live with this system on the 23rd of September, and it's going to take us time to roll it out. But what our challenge is that what we need to achieve with this is effectively to reach rural spaces, to take court online into the rural areas. And so that's quite a lengthy conversation, and it's a real challenge. But what I'd like us to think about, is the idea that someone who's living in a rural space will ultimately be able to access court papers on their smartphone without having to get into a car and travel or raise funds to share a car to drive to a town to get court papers. You can access court papers on your phone if we manage to roll out Court Online, which everyone based in Gauteng will know what it can achieve. So it's a unique opportunity, but it also presents immense challenges. But I believe we can do it. I can speak to the practicalities of what I'd like to do on each of these topics, but I would like to be guided by the commissioners as to which ones they would like me to focus on. But allow me then let me just raise a couple of other practical issues. I believe we need to strengthen various of our internal systems within the court system.
I'm sorry, I didn't catch that. Strengthen what?
Some of our internal systems.
Or internal
systems, yes,
right.
Within the court system, within our court system. So what I'm thinking about here are issues such as mediation. Again, it's an ambition of the Land Court Act that mediation gets more fully embraced. And we're not yet in a position to deliver that practically. We are working on it, and I believe we're going to get there. But I think that's critically important. One can see the potential benefit of that, for example, in the many disputes within communities who are still trying to finalize restitution matters. 20 years on, it's unsurprising that you have divisions within communities about how to resolve these issues. And I believe mediation, properly resourced mediation tool, will facilitate the finalization, the satisfactory finalization of those matters. Another issue would be our assessor pool, and there again, assessors are a critical feature of what we do because it allows us to bring in people from diverse backgrounds to sit with judges when adjudicating matters, especially restitution matters, to bring in different perspectives in understanding our history when we deal with those cases. I believe we need to improve our interpreter pool. For obvious reasons, language in our court is a real issue. And we do make heavy use of interpreters. In my experience, when we do it all the time, sometimes we'll have as many as 4 languages in the room. And as I see it, it's really critical that the people who are assisting with translations are highly skilled and able to speak in what is described in courts before me in deep vernacular, to do it really effectively so that the court process is dignified and restorative of people's dignity. The other issue the other internal system that I would say we need to focus on is stakeholder engagement. We engage with our stakeholders frequently, and there are many of them. The JP has provided, I think, extremely effective leadership in getting this going in the last couple of months. And we've seen many stakeholder engagements already on the go. But we do need to bring people into our discussions, and that's going to take time, and we need to focus on that. And then I'd like to highlight 2 more issues. The first would be what is a critical issue about accessing the land court. I believe that as we sit here now, far too few South Africans truly understand or know how to access us in Randburg, or even know where we are. And that's a problem. The court that we build needs to be a bastion of access to land justice, and that means we have to be accessible. And in order to achieve that, there are many sub-themes. I'll raise a couple, I think, which will be known to commissioners. There's a profound inequality of arms in the litigation space that between litigants who come before us in their representation. There's a new land unit at the Legal Aid in Legal Aid South Africa who are currently being brought into the space and are being given a lot of experience and responsibility in fantastic matters. And I believe that in 5 years, we are going to see a new generation of land lawyers coming out in this country. And I think that's a wonderful thing. And we need to put our energy into making that real and widening access to land law amongst mainstreaming, I think is the language I used previously in this space, mainstreaming land law amongst practitioners, bringing more people in. It's also about access to advice officers. We've been working on that, and I think we're making good progress there. And it's also about how we as a court communicate with the public. I think we've got quite a lot to learn from the Constitutional Court in how it's gone about communications with its court summaries. I think the Constitutional Court was the first court to routinely prepare court summaries. Yep. And it's now been rolled out, I think, in other courts. And I wonder whether that's not a tool that in our court we can use quite effectively to communicate broadly. But we would have to do it in, I think, quite creative ways because of language. We'd need to make sure that these summaries are translated, and we'd have to make sure that they're distributed in ways that can reach people in rural areas and perhaps through radio stations and social media. So I think those are some ideas. And then I suppose, finally, I'd just like to emphasize this issue of mainstreaming land law. For far too long, land law has been a kind of marginalized subject that's seen as a sort of specialty. And yes, of course, those of us who've worked in the area can say that we've acquired a level of specialism. But any practitioner can practice in land law. You just need exposure to the work. And you need exposure to the work. That's what you need. And I'd like to see far more lawyers in this country knowing land law. And I'd like to see, and this is in a sense beyond our purview as judges, but we are engaging with stakeholders about university curricula and trying to see land law. Well, what I'd love to see, if I had the influence, To achieve this, I would love to see land law being a requirement in any law degree in this country, that any South African getting a law degree needs to have a good understanding of our history of land disposition and how it's affected our spatial geography, because we're still living with it day to day. Perhaps I'll stop there, but I'm happy to speak to, perhaps with questions, I'm happy to speak to what we're doing in each of those spaces, because we've been working on each of them in the last few months.
I have no doubt that the commissioners will flesh out some of the issues with you. But thanks for that synopsis. You seem to have your finger right on the pulse of things. And I must just comment that the challenges you mentioned cut across the entire judiciary. Access to justice still remaining pie in the sky for many ordinary South Africans for various reasons. And then you have all the challenges, including the staffing issue, both on the judicial and administrative fronts, which is terrible, especially with the burgeoning litigation that engulfs our drowning courts. I mean, everybody knows that litigation has just exploded in this country, and unfortunately, there's been no concurrent, beefing up of resources, human and otherwise, in the judiciary. So I wish you all the best, all of us, all the best as we tackle these issues. Do you have any reserved judgments?
I've got one reserve judgment, which is, it's still within the 3-month period, which I will be handing down in the next couple of weeks.
All right. So you've managed to juggle the admin and the core judicial duties.
I have, yes. I mean, it is a challenge, and there's ongoing conversations with the JP about how to balance that, and to work out where one's resources are best spent. So I have been carrying a very heavy judicial load over this time as well, especially in the case management space, which I think anyone familiar with our processes will know that case management is absolutely critical for getting matters onto our roll. Our roles are not full enough. So I've had a very heavy case management load, and I love doing that. So it's quite hard to pull me out of those cases. But yes, we're going to have to learn how to, all of the judges need to get involved in all of the projects in the courts. The approach of our JP is inclusive. She wants to see all of us involved in building the court, and trying to make the best use of our talents and to distribute work accordingly. So it is going to be a juggling act, I think, going forward for all of us.
Yeah. Well, you'll have to give me tips on how you manage to maintain the balance, because I'm struggling. All right. I'll hand over to Judge President. I'm sorry. I didn't see you. Good morning, JP. I'll hand over to Judge President Karelse to put questions to you if she has any.
Good morning, JP.
To get used to this, thank you. Judge Cowan, you have touched on a few of the issues, our challenges, but what is your understanding of our operational challenges in relation to our caseload, financial resources, logistics, and human resources? If you could just, and I think most of our meetings currently have been around these issues.
Caseload, logistics, management.
And I think you can come in here with the project.
Yes.
The very ambitious project that we've undertaken at the Land Court. It's the Historical Restitution and Labour Tenants Project. If you can just
speak to that.
Speak to that as well.
Thank you very much. Yes, sorry, I turned off my microphone again. Yes, there's a project in the court which we call the Historical Cases Project. And it's a project that I spoke about briefly during my last interview. And what it's really aimed at doing is understanding why it is that there are so many cases that get referred to the land court that become inactive and are not finalized. And we've been looking at those statistics, which have been coming out in various ways. And we believe we don't have finalized data yet, but we believe that we're probably looking at about 1,500 cases that have become inactive. And we can close our files in the sense of we, as judges, can't do anything about it at this moment, but one can't close those files with a clean conscience in circumstances where we know very well that the reasons why these cases are not being finalized are probably no fault of the claimants or the applicants. So the project is aimed at making sure that we understand that data, that we know exactly which cases have become inactive and why, and that we find ways to reactivate them. So there are two strategies for reactivation. The one is about putting cases that are what we can flag as ripe for case management under active judicial management, and we're already well in the process of doing that. So as we complete auditing a particular year or period of time, we pick up the cases that we think are ripe for case management, and we allocate them. The JP will then, they'll land on the JP's desk, and the JP will then allocate them appropriately to a judge to case manage. And through that, we intend to get those matters on the roll and finalized. And then the second strategy is a far more ambitious one, and it's one that I think is probably unique to the land court, and I believe we need to embrace it. And the JP supports this project and is right behind it, for which I'm very grateful. What we're doing is we are partnering with our stakeholders and engaging with all of our stakeholders, but it engages Legal Aid South Africa, it engages the Commission, and it engages the Department of Land Reform and Rural Development, and it engages, and these are two critical agents in the new process, it engages the Legal Practice Council and the advice officers. So what's happening is that when we identify cases that are inactive, but that are not ripe for allocation to case management, the judge can't do anything with them. What we are about to start piloting, and this is with the cooperation of the LPC and Owesome and Legal Aid South Africa, is a process where attorneys on a pro bono basis are going to assist us to manage those files and take various steps to work out precisely why it is that that file has become inactive. That will involve engagement with the Commission and the Department and Legal Aid, see why is there no legal representation, what's happened in the Commission, and so on. And then it's also going to involve, the advice officers are going to play a critical role of providing a bridge between the court and communities, and actually go to claimants and try to support them in reactivating their matters if that's what they want to do. And if that's what they need to do, if need be, by securing legal representation for the case. So it's a very ambitious project, but it's about to be piloted. I do need in this room to acknowledge the support of, there's a commissioner in this room, Commissioner Motolo Tlepu, who's been actively involved in this project, so she knows exactly what I'm talking about. And also to acknowledge Owesome. As an organization, they are very excited about this, and their community, or their paralegals are already being brought into the project. We're about to start rolling out training so that people can be assisted in how to approach this, because it's not an easy task. If one goes back into a community that's been sitting for sometimes 20 years, to try and reactivate a case, it's not straightforward. And so we're trying to, again, engage with stakeholders to see how to do this in a, in a appropriate way. So that's what we're doing. But the logistics and the resource constraints are, which is what the JP is alluding to, are extremely heavy. And as a court, we're struggling to deliver on this. We will do it. It's the last thing I do. It's what I'm going to do. But we don't have enough researchers to help us. We don't have enough admin staff to work on the files. We don't have enough data capturers to capture the data. We're struggling still with, we're working on Excel spreadsheets, which we don't have sufficient skills to develop those sheets into a proper database. So we just don't have the resources to do it. But we are rolling it out with what we have. At the moment, we're going to pilot the data from 3 years, which is the years from 2013 to 2016, because that data is in reasonably good shape, we believe. In fact, there are people working on it this week, and we're hoping to finalize that data in the next week or two, and we're hoping to start training in about a month. But most of this is off the back of people who are volunteering their time or through other stakeholders who are supporting the court. And ideally, the court would be able to do this without having to reach out in this way. So, JP, I hope I've answered the question. I think you're...
Again, a long career spanning over more than 20 years.
Yes.
And you also held many leadership positions. Can you tell me how does the leadership that you acquired over a period of time in different areas have contributed to your legal career and the work that you're currently doing in the land court?
Yes, thank you. Yes, I mean, I practiced for 20 years at the bar, initially in Cape Town and then here in Johannesburg. I actually moved up to Johannesburg. Well, in Cape Town, I had a lot of cases that were involved the interaction between customary law and gender. So I was involved in the cases that secured property rights for women who were living under customary law, the Bear case, the cases that dealt with primogeniture and the property regimes governed in customary marriages. And that's helped me to understand a lot about what happens in the spaces where we work and how cases can be run effectively in those spaces. When I moved up to Johannesburg, one of the main reasons I did so was because I was offered a position at the Legal Resources Centre. And one of the primary areas of work of the Legal Resources Centre in the Constitutional Litigation Unit was rural land work. And I really wanted to do that. But through that, I was exposed to working with communities in land matters. And again, I think that's given me an appreciation of what's required in order to finalize extremely challenging cases. And I think that helps me as a judge, and it helps me to help litigants. We have inquisitorial powers in our court, as you know, JP. And I think that my experience in this area of law allows me to use those powers effectively to assist people to finalize cases, hard cases. And then I suppose, in other leadership positions throughout my career, I've always tried to put my hand up to help with whatever is needed in the space where I am. So at the Legal Resources Centre, I acted for a period as the acting director of the CLU. And at the bar, I would put my hand up for committees. I served, for example, on the committee. I served with Commissioner Beloy as the co-chairs on the committee that was revising the sexual harassment policy for the Johannesburg bar. So that kind of committee work has helped me to understand how to work within an institution to build its systems. And I think there are many examples that I could point to. I worked in the state on the legal committee for the Medicines Control Council, which also helped me to understand something around how the state works. And I suppose the final one I'd mention is my time at the Constitutional Court. I was there as a clerk for the late Chief Justice Chaskelson at an extraordinary time in history. And we were, so I hadn't, at that stage I was just his researcher, but I had an opportunity to observe him and the late Chief Justice Langer in leadership, and to watch what they were doing to build the Constitutional Court. Yes, and such as the Parliamentary Monitoring Group, creating the Parliamentary Monitoring Group when I was in my first job. That was a joint initiative of IDASA, Black Sash, and the organization I was working for, which is the Human Rights Committee. So I've got a sense of how to build institutions.
Just one last question. You mentioned that you were involved in putting together sexual harassment policy.
Yes.
That's what I recall. And I think yesterday the spokesperson for this body also mentioned the sexual harassment policy. And I'm aware that the heads of courts, the Chief Justice, that policy is in its draft form. If I may ask you, if you were faced with a complaint of sexual harassment as DJP, how would you deal with it?
Thank you. What I've learned from, well, firstly, the first port of call would need to be the policies that are put in place within the institutions, and obviously it's a critical step forward within the judiciary that we've got a sexual harassment policy that we can turn to. So I think that's a critical moment, and that was happening before I was on the bench, so I haven't been involved in that process, but it's something that I support. In my experience with dealing with sexual harassment matters, which I've dealt with both from this perspective of policy development and representing people when I was at the bar, there are various dimensions that need to be observed. The one is that most policies distinguish between the formal and the informal process. And the informal process becomes really important in trying to mediate as a first step often, if it's what people want to do. If the complainant wants to follow an informal process, it can become critically important in mediating what are very difficult power dimensions. So the first thing I would do would be to explore whether following an informal approach is the right thing to do in that case. I'd have to engage on questions around confidentiality, because obviously the power relations are such that can play out very harshly in a given case. There are some cases that can't be dealt with informally because they're so serious, and one needs to I think sometimes there are times one has to override the wishes of someone to keep something low key because of the seriousness of what one's dealing with. And then I would see my role as ensuring that the formal process can be followed in a way that's very supportive of the complainant. Complainants need support in these processes, and there are different ways in which that can be shaped. But I would pay a lot of attention to ensuring that the complainant was duly supported through the process that would then follow.
Thank you, Cedric.
Have you finished, JP?
I think I should finish now.
Thank
Give
you.
other commissioners an opportunity.
All right.
Speak the whole day to
Just one follow-up question on the last question that was put to you about sexual harassment. You speak of an informal approach and a serious, and I guess versus a minor case of sexual harassment. How do you first? What is the informal approach?
Thank you, Chief Justice. The informal approach with which I'm familiar in the areas where I've worked, and it's not always appropriate, entails it can entail different things, and it partly depends on the wishes of the complainant as to how they want to proceed, because sometimes complainants simply don't want to reveal their identities. And if that's the case, then you become quite confined in how much you can actually do for fairness reasons, because people need to be given due notice of any complaint against them from an Audi perspective. But if you can, there are ways, and there's certain circumstances where you can resolve problems in the workplace without even revealing someone's identity, and that involves partly educative processes, and it involves partly engaging the alleged aggressor in a way that speaks to what's required in the workplace, but that isn't accusatory of specific conduct. So one tries to, you take the information that you get and say, well, this is happening in the workplace, and you then try to, you use your influence to say, well, this is how we want things done. We don't want things done in this space for this reason. But you can't go from there to a formal disciplinary process because of Audi. There are other informal processes which will depend on consent, so mediation will be consent-based. Sometimes it's just a matter of sitting with two people, the two people involved, with an independent person, but in a not a formal mediation, but you try to navigate that space. And then I suppose in leadership, sometimes as a leader, you might be the right person to do that, but quite often it will be someone else. And what's important is that you have relationships with people who are able to perform that role, who can step in and say, well, I'm happy to sit and talk this through and ensure that the right standards are being observed and what's expected of whoever it is, if it's a judge or a member of staff who's the alleged aggressor. And then the formal process is a formal disciplinary process, as we know and understand them, where you're in the formal space. So the informal process is something that one can try to follow without going that route.
I question you cautiously, because the institution, the judiciary, that is yet to disseminate its policy, although it is there. But I just want to ask, since you say you have had occasion to deal with cases in this area, do you have a definition of sexual harassment and perhaps examples of a minor case as opposed to a serious case?
I do have definitions. I don't have them with me, and I'd want to pull them out. But I think that what's at the heart of the definition really is around unwelcome conduct of a sexual nature, and which generates discomfort. So it's quite a low threshold, actually. When you look at I think the more progressive definitions of sexual harassment, you come within the definition quite quickly, and partly because of that. And then there's a debate about whether it's an objective or a subjective test, or something in between. But I think partly because of the challenges around, partly because there needs to be a wide definition. There can be an example, for example, I think the example we were using in one of our policy spaces was, what if someone comes up to you at the photocopying machine and smacks you on the bum or something like that, which many people would regard as highly inappropriate, and others might not. The view that I take of it is that's not something that should happen in the workplace, and it's not something that should happen in the judicial workspace. And sometimes, but that's something that you might be able to deal with in a firm conversation. Someone might not realize that what they're doing is causing it, but once told, will never do it again. And so one can sometimes use persuasion to stop it. Or just making a remark that's uncomfortable. But it often will depend on the context. So something that's minor to some may be serious to someone else. So it's very context dependent, and one has to be sensitive to the actors involved. It's a very complicated conversation.
Well, your answers just stress the urgency of getting the sexual harassment policy out as soon as possible. Suffice it to say that I don't think there's any person who would like to have their bum smacked by a person that's not, that
No,
is
no.
not in a relationship with them.
I agree with
So,
that.
yeah.
And but what I've heard, I mean, certainly in the bar, that kind of conduct was very prevalent, and one was involved in those conversations. And the question is, well, should this trigger a disciplinary process, or can we resolve this in another way? So I think that once one's in the judiciary, I think that kind of conduct, there's simply no place. At this level, I can't see that there's any place for that conduct.
Yeah, I'll leave it here.
Chief Justice, if I may make just a follow-up. Yeah. On this particular point, just for me. I mean, my interest is because of your suggestion of informal process and the formal. Do you accept that the whole issue of sexual harassment is a complex one? Is a complex issue, which would bring into play the issue of value system, the cultures, and everything. The point is, whose values must be applied when you take, because there must be drawing lines in each of the instances. For instance, if you grew up in some rural areas, boys would be sitting in some corner. If they see a woman, they would speak, but that to some other is harassment, quite purely. And then there are stages. How should one go about this really? Because it seems to me that the proposed informal approach, because it's where you establish, so that we are able to go to the formal approach where you have drawn those lines. So I just wanted to elaborate on that.
Thank you, Commissioner. I mean, what you raise, I think, is very important. And there's, I don't regard myself as a specialist on this by any means, but I have read a fair amount about it. What I understand is that in most policies, there is the fact that people come from different places and with different traditions, even in greeting, is something that has to be taken into account very seriously and has to be factored into how one approaches responding to any issue. So it has to, yes, I would agree that. I think it's obviously clear. It's clear that differences in cultural differences is something that has to enter the conversation, and it has to be done in a sensitive and, you know, we need to listen to each other and understand where we're coming from, because what's offensive to one person may be absolutely normal to someone else, and we need to understand where we come from. I would agree with.
Thank you.
Would I just follow this up? We may not know how to feel Commissioner Nokesi, because the cultural practices you referred to, someone may have a whole argument about the patriarchy, you know, around those and so on. But
Chief Justice, I do want to follow up because I don't want the cut to be misconstrued as an endorsement of the question.
Yeah.
Because there is a risk that we will end up there. Judge Cohen, you know, when you began this conversation, you were clear that the definition of sexual harassment is unwelcome conduct, number one, of a sexual nature, number two, which causes discomfort, number three. Now that applies to all cultures and to all contexts. Is that correct?
Absolutely.
Thank you, Chief Justice.
Commissioner Mtsweni-Sipane.
No, thank you very much, Chief Justice. Good morning, Judge Cohen.
Good morning, Commissioner.
You have acted in many roles. You've been a judge for relatively few years, and you have also deputized for the acting judge president in administrative roles, such as the shortlisting for court management and reviewing court performance statistics. How would you leverage these experiences to manage the land court effectively as deputy judge president, particularly in coordinating land restitution cases and liaising with the stakeholders like Legal Aid South Africa?
Thank you, Commissioner. Yes, I have, as you indicate, I have I've provided leadership support in the ways that you've mentioned. So my involvement, for example, in the rules and around the rules board and I think will be very useful in supporting the JP in her work. We are in a position where we need to revise all of our court directives, and this has given me the opportunity to do so, and given me the confidence to assist her and support her in that role. Over the last 4 months, when the JP arrived on the 1st of June, she really did hit the ground running. And we've seen enormous progress just in these recent weeks, in trying to roll out some of the programs, for example, the Court Online program. And so the experience that I've got in deputizing over the last few months, I think does position me well to support her. I think it's a question for the Judge President as to who she would like to be supported by. But from where as I stand, I feel comfortable in that role. In terms of stakeholder engagement, I now have extensive experience. Actually, that started well before I started. Before I deputized or sat in any formal role, I was involved in liaising with legal aid, for example, liaising with the commission and the department. So I've established relationships with the stakeholders who are affected by the work that we do, and I think they're good relationships, and I'm able to bring that to the role of deputy.
No, thank you very much. My second question will then be that looking at many of your judgment, you have focused on land-related dispute and land restitution. How do you view the current challenges in land restitution claims, and what strategies would you implement to improve the efficiency and fairness of the land court in handling these sensitive matters?
Thank you, Commissioner. The challenges that we're facing in restitution cases are immense, and it's right to prioritize them. The real one is, well, the big picture challenge is the backlog. And there what we're looking at is of the old order claims, which means claims that were lodged before 1998. We're looking still at a figure of just under 6,000 claims that have to be finalized. And that's not factoring in the new order claims, which are currently interdicted, of which there are tens of thousands that currently cannot be processed by the Commission. So the first step is to realize the enormity of the task that we're dealing with. It's enormous. The Commission is telling us at the moment that it's going to take 30 years to settle the 6,000 claims at a cost of 172 billion rand. So if one looks at those stats, one quickly appreciates what we're dealing with. The historical cases project that I mentioned earlier is intended specifically to deal with that, at least in as much as it's under the control of the court. So while we can't activate, as judges, one can't activate a case that needs to be done by the litigants. What we can do is empower those who are able to do it to do so, which we're trying to do with reference with the project that I was referring to, and I think that is probably the best strategy that we have to do that. But we need to also look more deeply at some of the problems. So Legal Aid South Africa, I mentioned, has established a land unit, and the unit is they've recently employed, I don't know the precise numbers, but I think it's in the region of, they've got 100 new land lawyers. Now, some of these land lawyers are very experienced and are able to handle any case that comes their way, and others are new to the space. And what we need to see over the next few years, that these lawyers are fully capacitated to deliver on on what they have to do, which is an enormous task. So I think empowering the legal aid practitioners is quite an important part of what we're doing.
Sorry, Judge Cohen, if you can just inform the Commission, with your permission, Chief Justice. Yeah. One of the projects that we undertook in these last few months was also training. And training is we've decided to take and do our own training because of resources. And one of the projects was to train legal aid. Could you just give the Commission a sense of how many provinces we've trained as the judiciary?
Yes, so the training project was a project that was initiated by the previous acting Judge President Meer, and it was done in collaboration with Legal Aid South Africa. It was on their request, I think, and all judges were involved in it. And we went, at this stage, we've been to 3 provinces. So we started in KZN, we went to the Western Cape, which was also servicing the Eastern Cape practitioners, and we also did a training session in Gauteng, which was also servicing legal aid practitioners from the northern provinces, and Mpumalanga Northwest. So at this stage, we've done 3 sessions. We've been covering the main statutes, which is at this stage ESTER, labor tenancy and restitution. But we've also been, so that's the immediate training program we've been working on. But there's a kind of bigger picture that we're looking at, which is appreciates that to have an effective land restitution case, litigants, claimants in particular, need to have access to more than lawyers. Often what they need access to is historians and experts. You need access to land surveyors. You need access to sometimes it's just you need resources. And what we're we'll be engaging with stakeholders to make sure that all the right people are talking to each other to ensure that there's access to these resources.
Thank you, Chief Justice, and good morning, Judge Cohen.
Good morning, Commissioner.
I don't have a question. I just wanted to commend you and the JP for the project of encouraging legal practitioners to do pro bono. There's a lot of interest in the historical cases matter. At least there are few people who walk the talk, and yourself and the JP do that, and we really appreciate it. Thanks.
Thank you, Commissioner. And we'd like to thank the LPC for the LPC support. Without it, we would be nowhere.
Was that your only question, Commissioner? All right. Commissioner Shabangu Mtau, did you have your hand up? No. Okay. Commissioner Minister.
Thank you very much. Judge Cohen, good morning. Are you good?
Good morning, Minister. Yes.
Thank you very much. One of the criticism, at least for government, is that the country is slow in the pace of dealing with land claims. What are the practical measures you believe should be put in place to ensure the resolution of land matters and that they are dealt with expeditiously? I mean, the litigants are mostly coming from marginalized and rural communities. You touched a little bit on it, but I think you could still elaborate and see what measures really can we put in place.
Thank you, Minister. May I just ask for clarity? Are you asking from the court side or are you asking from any of the branches of state? Because some of these are obviously matters for Parliament and the executive. Are you wanting my perspectives?
From the court side.
From the court side.
Thank you.
No, thank you. So I think that, as I see it, the court needs to take we need to take an ambitious view of what land justice is about. If the truth is, and this is not a happy truth, but the truth is that the land court for a long time has, I think, practically been a place where evictions are resolved, eviction cases are resolved. So I think for many judges who've come to act, what they will have found is that the cases that land on their roll are ESTER eviction cases. And that's not okay. The land court cannot be a place that, in this day and age, is mediating the evictions of farm workers. That is simply not delivering on the promise of the Constitution. So what we need to achieve is that, and this is what the Land Court Act that Parliament recently passed enables, is by introducing permanent judges, we need to make the court a place where people know they can come to get restitution, to mediate redistribution disputes, to finalize compensation disputes, and to do it effectively and efficiently and quickly. So we have to confront the problem of delay, and that means building a new court. It means, and unfortunately, and I'm afraid I do have to put this back in the executive's hands, we need resources. We're not going to be able to do this on goodwill alone. We are going to need to be properly resourced. One of the ways in which I've supported the JP is, over the last few months, as in the role of deputy, is to assist her in developing the proposals around what judicial resources we actually need, and then to work with the OCJ in trying to understand what kind of staff component we're going to need in order to support this. But at the end of the day, we need a properly resourced court in order to deliver on what the promises of the Land Court Act are, which are vital to delivering on what the Constitution promises. And there are other, practical things, I think, which we are working on. So working with Legal Aid South Africa is critical. It's critical. We have to capacitate the legal sector, the pro bono legal sector, but the legal sector more broadly, to deal with land matters. I use the language of mainstreaming land law, and judges can be very, we can be instrumental in that. And it's not only about us, it's about generating interest and excitement amongst the profession broadly to get involved in this. I think I mentioned at my last interview that, what my experience is that almost every practitioner I speak to gets excited about land law and wants to get involved. South Africans want the land question resolved. South Africans want to see land justice. And we need to do what it takes to get people active in this space. I don't think it's that hard. I think it's about, I think we're already making headway. I think we already, stakeholders are already getting excited about the work that we're doing. We're already bringing them in. So it's about bringing in stakeholders, getting people excited to do the work, and opening up the channels to make sure that claims can actually be finalized. So, that's a high-level answer, I realize.
Commissioner Moiman?
Thank you, CJ. Greetings to yourself and the commissioners. Good morning, Judge Cohen.
Sorry, good morning, Commissioner.
Just one from my side on the point that you closed on, that justice to communities on land rights is important. Now, in relation to communities living on communal land, they do not have a full title as the land is registered to the state. The only right that they have is to occupy. And at the same time, you have 800 traditional councils where you find these communities. And after 30 years, government still shies away from full title of ownership to those communities, which perpetuates injustices to people living under those traditional councils. At the same time, traditional leadership want the land to be transferred to them. The dichotomy is that with Communal Land Rights Act, which created dualism in property regime to try to address the security of tenure, it was set aside by the court on the basis of the fact that it's unconstitutional, as it creates dualism to the people living from rural areas and also urban areas. What is your view in relation to what could be done to ensure that also those people living on communal land get the full benefit of ownership as envisaged in the Bill of Rights in terms of the rights to property? Thank you.
Thank you, Commissioner. This is a very large, difficult, and terribly important question that you've asked. But let me let me give you my views in this way. I've come across this issue in a number of different forms, and I think some are easier to respond to than others. So, for example, I've seen cases where title is still held by the state nominally in trust for a community, a traditional community. And that comes from the old titling regimes right back to the 19th century. And you'll find that often in the northern provinces, I think, in the northwest and in Limpopo, Mpumalanga as well, I think. And those trust regimes, if the community is as long as the community is not divided around the issue, I think it's very easy to solve, because there's absolutely no reason why that trust regime should still be in place. If people want to have control over their land under common law titling, then those trust regimes were imposed for paternalistic and discriminatory reasons. They were not imposed, they're not customary law trusteeships in any customary law sense of the term. So as I see it, in those kind of cases where you have cohesion within the affected groups, it should be a simple matter to convert that title into title in the name of the traditional community. It gets more. And then, of course, the way in which land rights are asserted on the land itself will depend on the customs of that community. So you'll there see a dualism between the common law titling and customary law systems of ownership. And again, if you have a traditional community that is not divided, then there should be no reason why it can't be done easily. Where it gets very difficult, I think, is where you have divisions within traditional communities about what solution is wanted. And those divisions, in my experience, can go even to what that original trusteeship it was intended to be. So if that trusteeship was meant to be a trusteeship on behalf of the entire traditional community, or if it was intended to be a trusteeship for a smaller group or a syndicate who had purchased land, often buying back ancestral land, it's a terrible part of our history. Those are harder to resolve, because you will then find tensions between the traditional community, the traditional leadership, and some groupings within that community who will say, well, we want title in our names as a smaller group, and the traditional community saying that, well, we want title in the name of the traditional community. And I think that those the ideal solution to those kinds of disputes is through mediation. But I think at the end of the day, some of those big issues are just going to have to be litigated, because they can be quite intractable. And sometimes it's just going to have to be resolved under law, what was intended by that original trusteeship, for example. And I was involved in a case of that nature when I was in practice.
Just the last one. I think
how many have you asked? Just one?
One.
Okay, but it's taking a lot of time, and we are running into trouble in that area, Commissioner. Just bear that in mind.
Thank you, Chief Justice. Maybe just the last point. I think the only challenge that I suspect it relates to the approach that the government takes in terms of their reluctance to accord full title as set out in the Deeds Registries Act, and the argument is that it will take more than 100 years to accomplish that, because they say it will be expensive to survey and register every homestead, and it will be unaffordable, which to me perpetuates discrimination and marginalization.
Yes, thank you, Commissioner. I mean, I agree with you. I think that the position of rural South Africans, and we're talking, I don't have the precise stats, but we're talking about 20 million people, of which many are affected by these land histories and are still feeling the impact of that colonial history today as if it happened yesterday. And we see that narrative in our courtroom whenever we have a restitution case before us. So it's very alive and real and palpable. And as I see it, as a country, we have to prioritize it. We have to prioritize the resolution of these disputes in our rural spaces.
Thank you, Judge Cohen. Thank you, CJ.
Thank you, Commissioner Moimang. And just a reminder, colleagues, we agreed on crisp, concise questions, please. Lekganyane.
Thank you very much, Chief Justice. Good morning to
Good
you,
morning, Commissioner.
Judge Cohen. The issue of land in this country is very contentious, and its centrality to the resolution of the national question and its attended class, race, and gender complexities cannot be overemphasized. And if we are going to be true to what is written in the preamble of the Constitution of the Republic, I would want to get your impression, given the accolades that have been presented before us on your record dealing with land issues. How do we succeed in building an inclusive socio-economic development if issues of land remain unresolved? Thank you.
Thank you, Commissioner. I mean, you know, I have, in my experience, or the bulk of my professional and judicial experience is dealing with disputes in rural spaces where we are seeing precisely this interaction between class, race, and gender. And I mean, you asked the question: how do we resolve this so as to ensure inclusive social economic development? I suppose as I see it, we won't achieve inclusive social economic development until we address full-frontedly the rural land question. It's absolutely paramount. We can't leave the rural sectors behind. And there's, as a practitioner, it was very clear to me that there's a heavy bias in our civic discourse weighted in favor of urban debates, urban political debates. And yet the rural sector is so fundamental. We're still living in our society, I think, is still fundamentally structured by the ways person of the Bar Council at that time. These debates were being had within the bar about how do we respond to what we know is a problem at the bar. And in the profession, I mean, that's documented and it hasn't been adequately responded to date. So this was a conversation, I can recall the conversation, and the main thrust of the policy that we adopted, and I think this is and should be the main thrust of any policy, is that it should be victim-centered. It must be victim-centered. The victim needs to guide how we respond, and it needs to be done in a supportive way, and it needs to be done in an empathetic and sensitive way. But the debate went as follows, that, well, what if there's a rape in your midst that amounts to sexual harassment? Or what if the conduct is of such a nature that unless you take action, what you are doing as a leader is effectively enabling the same conduct going forward? Isn't there a case of that when that's at stake? When the integrity of your entire institution is at stake, that you have to actually say, no, we need to take formal action here. We can't just sit back. And I think it's a rare case, but the decision that was finally taken in that policy debate and was finally approved by the bar is that such cases can arise and that we do need to make provision for it. I think it has to be victim-centered, but we have to appreciate that the integrity of an institution can stand or fall on our ability and willingness to take firm action when it's necessary.
Thank you, Justice Cohen.
Thank you, Commissioner. JP Mlambo.
Thank you, Chief Justice. Good morning, Judge Cohen.
Good morning, JP.
My interest is on the leadership role of the court. You mentioned a number of projects that the court has undertaken. I just need clarity. Are you personally involved? I mean, you mentioned the historical cases projects. Are you personally involved in all these projects?
I think I am, yes. The Historical Cases Project is a project that I initiated. And
okay.
yes.
I don't want you to explain anything. I just need to clarify.
I think I am involved in all of them, yes.
You say the court has recently gone live on Court Online.
Yes.
What is your involvement with that project?
Yes, so thank you. And the Court Online project is a game changer. I was the JPs led that process going live, and I've provided support to her. My specific activities were I assisted the JP in preparing the directive, the court directive that governs how we're going to roll that out. So assisted in. And we consulted on this. So we consulted with stakeholders around how to frame our directive. So I was part of that, and in one case led that.
So you were part of the directive. Now, you mentioned that you want people in rural areas to also have access digitally. You mentioned your contact with CAUSA. Are you driving that? Are you involved in doing that?
Yes, I am. There are two ways in which we are approaching that issue. So the way we're thinking about it is that because of the unique challenges of the court.
Well, I think I don't want you to explain anything.
Right. Yes.
Your appetite to roll up your sleeves and assist your leader. Right. Now, you said the court needs more judges.
Yes.
Do you have any sense of how many more judges you need? And please refer to the backlog that you say exists.
Yes, thank you, JP. Yes, the proposal that we've made, and that, as I understand it, is currently with the Ministry of Justice, is that we'd like to see an additional 8 judges appointed to the court. Now, those judges will be, and it will be over a period of time. So because we're currently struggling to get matters on the roll, we don't need all 8 judges now. But if we succeed in this reactivation process, and if we're going to truly deal with that backlog, and if we're going to embrace our expanded jurisdiction, we're going to need, I think, at least 8 new judges over the next few years.
Thank you. My last question, CJ. What is your leadership philosophy?
My approach is to be consultative. I think consultation is critical. It's inclusive. We need to include stakeholders. One needs to acknowledge your own limitations and you need to work with your strengths and identify the strengths of others. So you need to work as a team. Sometimes you need to take firm, decisive decisions that are unpopular. You need to be comfortable with doing that. But yeah, I suppose ultimately it's a consultative and inclusive approach to leadership, and that's aligned with the approach of the JP. She sees everyone in the court as being a participant in leadership.
Thank you. Thank you, CJ.
Thank you, JP. Commissioner Trollip.
Thank you very much, Chief Justice. Judge Cohen, you mentioned in the 10 judgments, important judgments, the Moloto versus Minister of Rural Development and Land Reform, the matter around determining market value, including a numerical evaluation of current use value. Why is it important to determine a proper market value of land that's to be expropriated, in your opinion?
Well, I suppose thank you for mentioning the Moloto case. And yes, in that case, what we were exploring is the relationship between what was put up in that case as the current use value and market value. And what wasn't wholly clear from the evidence in that case is how that relationship is going to play out in valuations. What I held in that case is that in interpreting Section 25(3) of the Constitution, that in principle there's no reason why a properly motivated numerical value can't be placed on current use. Now, market value is obviously one of the factors. It's only one factor in the determination of what's just and equitable compensation. And the Constitutional Court has made it absolutely clear that it mustn't be treated as the dominant factor. It doesn't hold priority in that process. It's one of several factors. And in that case, what was interesting is this idea of a current use value, which is what the Office of the Valuer General is concerned about and is trying to give content to. It allows a court in the process to not only consider, well, what is actually happening on the land, what use is this land being put to, but is also saying, well, how does that relate to market value? And is the land being optimally used? And if not, how should that affect the determination of just and equitable compensation? I'm not sure if I've answered your question, but thank you.
Commissioner Malema.
No, thank you very much. Good morning, CJ, and good morning, Judge. Just a follow-up. The CJ asked how many reserve judgments do you have? You said 5. But I saw somewhere there Nadel said 7, so I just wanted to reconcile that.
Yes, thank you, Commissioner Millen, and you're quite correct. There is a discrepancy in the comments. The GCB indicated that it was 5 at the time that I submitted my form, and I think it was Nadel pointed to the correct number at that time, which was 7. So that was an error in the GCB's comment, I think. So the correct position was at the time that I submitted my form, there were 7 reserve judgments. But as I sit here now, none of those are outstanding, and there's only 1 new reserve judgment that's still within the 3-month period.
You cleared them for this purpose?
Sorry?
You cleared them for this purpose?
I always clear my judgments.
Not they were outstanding, not so long ago, and before you come here, they are all cleared.
Well, I'll clear all of my judgments. I will pick up, I have quite a heavy role, and I will be accumulating judgments all the time. So the approach that we need to follow is always to clear our judgments.
What is your take on the current constitution? Does it allow expropriation of land without compensation?
Commissioner, I do need to be guided in some measure. I would like to answer that question, but I do need to be guided in some measure by the Chief Justice, because I need to be cautious about it, because it's an issue that can come before us. So the approach I adopted in my first interview was to indicate that I'm comfortable approaching it at a high level, but mindful that before I can ever make a decision on an issue of that sort, I would need to fully hear argument about from both sides, because it is a live issue and it will come before us. Chief Justice, are you comfortable with me proceeding?
Yes, in the same way you did the last time.
All right.
From
Thank
a
you,
high
Chief
level.
Justice. At a high level, yes.
Yeah.
And by prefacing what I say with that, I couldn't decide that without fully hearing argument. So my view, thank you, Commissioner. I mean, it's obviously a very important question that matters to a lot of South Africans, and there are, and it is going to have to be squarely decided by courts in one would hope in the relatively near future. As I see it, there can be no real debate about whether the Constitution properly applied permits of nominal compensation. I can't see how that's debatable, because even if one looks at the factors that are set out expressly in Section 25.3, even just by applying a mathematical formula, for example, if you look at the extent of state subsidy that may have been given to a white farmer in the past, and then you look at market value, or you can easily come up with a calculation that gets you to a zero balance. I think the more difficult debate is whether properly construed, the Constitution permits of zero as opposed to nominal compensation. And there I've read different arguments, and I don't know the answer. I'd really need to hear argument on it. But I do think that there are, given our history, there are compelling reasons that the Constitution fully embraces why there should be departures from market value compensation.
So will it be within the Constitution?
You're on a bad question, and the agreement was 2 per commissioner.
Huh?
The agreement among the commissioners, which you know, it dates back even before I started chairing this body, is that commissioners ask only 2 questions. 2 questions per commissioner per candidate.
Oh,
Yes.
Judge Mlambo didn't ask 2 questions. I was here. I listened to him. He didn't ask 2 questions. Unless there's some right reserved for other commissioners. I'm prepared to leave this question here, but in reality, if you go back to check the record, JP Mlambo did not ask.
Commissioner Malema, we are wasting time debating how many questions to be asked. Just ask your question and keep it as brief as possible. But that does not mean I'll be lenient with other commissioners.
Thank you. No, I just wanted to ask, will it be unconstitutional to pass a bill which allows the state to be a custodian of the land with the fully land use rights guaranteed, that no one loses anything, the state owns the land, and whatever remains, whatever is on the land remains in the pockets and the hands of those who are using that particular land, like we did with the minerals and like we did with water. What's your take on that?
Thank you, Commissioner. I have to be I'm aware of the political debate, and I've followed the political debates, which I find, they're important debates, and they speak to matters that are very important to South Africans. I don't know the answer, and I haven't heard, to be honest, I haven't engaged it in a legal sense. I've thought about it in a political sense. So I haven't, the truthful answer is I haven't sat down and tried to work it out from a legal point of view. But I do think that if one just thinks about it from a, as one, and I think there may be differences, I'm just not thinking aloud, which perhaps I shouldn't do. The simple answer is I don't know the answer. I think state can, at least in some cases, be a very useful modality to secure justice as a policy position, but that's just my own sense. I haven't thought through the legalities.
Thank you, CJ.
Commissioner Marumo Achai.
Thank you very much, CJ. Good morning to you and to all the commissioners. Good morning, Judge Cohen.
Good morning, Commissioner.
I've heard your vision and some of the initiatives and challenges that you have outlined. But I just want to pick your brain in as far as, yes, we understand that is insufficient judicial resources and some of the challenges that you have identified. And you have outlined that currently there's a difficulty in terms of enrolling matters. In other words, there is a backlog and those matters need to be dealt with. What discussions, if any, in the leadership core of the court have been had to ensure that strategies are put in place that even with limited resources, those kind of cases are disposed of in order for us to realize the constitutional purpose? Thank you very much, CJ.
Thank you, Commissioner. And this is a topic we discuss almost every day. It's a priority for us. Anyone who comes to our court can see that there's a problem in enrolling restitution cases and labor tenancy cases. The strategies we are already adopting and which I think are showing results are the primary judicial strategy is to case manage. So we've been doing this now for several years. This project had started even before, or started around the time that I arrived on a permanent basis. So cases at this stage, all cases from 2016 that arrived and referred to the court in 2016 have been flagged, and all those files have been pulled, are being allocated to judges for case management. So you'll find that, so if you were to look at my diary and you were to look at my role, you will see that I have far more case management hearings in the land court than I do have actual hearings. I am hearing restitution matters, and I'm one of the judges that have, because of the time I've already been there, I've been able to get matters to the point of enrollment. So my role is getting fuller. But for a new judge who arrives, until you can case manage to the point of enrollment, you're not going to get matters on the roll. So it's a critical tool. And so we're developing practices in the court around case management. The JP just last week or the week before, I think it was, ensured that we had internal discussions around best practices for case management so that we can learn from each other. And so that we need to develop best practices for case management. And it's different to the High Court space because we're often dealing with unrepresented, marginalized rural litigants. So for example, one of the strategies we use is, one of the first things you look at is there a problem with representation? And if there's a problem with representation, we literally pick up the phone Legal Aid South Africa and say, please come to this meeting, and they come. They're working in a very cooperative basis with us. We've got good relationships. They'll come to the case management meeting, and then we will make sure that the parties are represented. Another strategy is we have a look and try and pick up what are the typical problems in delay. So one of the problems we see often is that there are difficulties with the gazetting of land. So when claims were lodged in the early gazettes were not done properly, and we will make sure, so one of the first interventions will be, has the land been properly identified and has the land been properly gazetted? Because if you don't get that right up front, you're looking at delay. So we identify strategies for intervention, and we do it up front, and in this way, we get everyone around the table, we agree on sensible, practical ways to navigate the issues in the case to get it to enrollment as quickly as possible. So it's going to be, and again, that talks to our need for more judges. The JP has been very proactive in getting judges and other judges involved in, including retired judges, involved in some of this work. So we are drawing on the resources of our retired AJP who's able to work in the most effective way, just from a case management perspective. So bring people in, help us case manage these cases just to get them enrolled. So we talk about it every day. Yes.
Thank you very much, Judge. Thank you very much, CJ.
Thank you, Prof. Commissioner Jozitube.
Thank you, Chief Justice. Judge Cowan, you have spent the majority of your time outlining the sort of pragmatic problems of how to get things done in the land claims court, and it's very admirable, your knowledge of the land ecosystem and your knowledge of the processes of the court itself. But there is another role to the position you are going to occupy, which is that of intellectual leadership. So I fear we're not giving you enough questions that are challenging you intellectually. So maybe let me fill that gap. I agree with you fully when you say the government is to blame for the problem of landlessness and land injustice. 100% they are to blame for it. They've dilly-dallied, they've adopted the wrong policies, they've defunded land, they've defunded the Land Claims Court, they've defunded the Land Claims Commission. So every charge in the charge sheet has been established. But I think that the judiciary must also take responsibility for the way in which they have handled the jurisprudence of land. Now, I want to give you 4 examples in which they have constrained the ability to reach the constitutional vision that is outlined in a very ambitious section, Section 25. Firstly, they have adopted a narrow definition of community, which has excluded numerous communities from being able to obtain land justice. And that's purely a jurisprudential thing. There's nothing in the Constitution that requires the judges, particularly of the Land Claims Court, to adopt such narrow constructs to the definition of community. Secondly, they have put restoration as an entry point to debates of feasibility, as an entry point to debates about restitution. And what that means is that you end up with an artificial argument about the feasibility of restoration, which focuses on the financial feasibility of restoration, and without asking whether or not the landowners that own Sentin live here. But you ask the same thing about communities. Are they going to live there? But the owners of Sentin are living overseas, and nobody's asking that question about them. Thirdly, they have used market value as a starting point in the assessment of compensation. Again, it was judges who decided that market value would be a starting point in the assessment. Fourthly, they have found in many cases that people that were dispossessed were in fact labor tenants, and which disables them from claiming fully fledged ownership rights, because the judges have decided they were labor tenants. And then finally, they have adopted an approach to land that is sort of common law centric, right? So the debate is land property or not. Now, I've put this to you because out of the judges and the judgments I've read in the Land Claims Court, yours are the most promising, the most radical, and they show the ability to break with the straitjacket of the common law. And maybe if there is any hope, it will be in a lot of the judgments that you have written. So maybe you want to say something about the intellectual challenge of breaking with the tradition in order to give effect to the constitutional vision in Section 25.
How long do I have?
No,
I think 30 seconds.
Unfortunately, he has taken all the time that is allocated to the interviewee to answer, because that was anything but one question and nothing close to short, crisp, and concise.
Judge Cohen,
do your best.
I leave it to the Chief
Cohen.
Justice to decide what to do.
Just do your best.
Thank you, Commissioner. And I do think that when I noticed in the preamble to the Land Court Act, Parliament itself speaks about the need for progressive jurisprudence, and I'm interested in that because there seems to be a recognition by Parliament itself that there's a need to shift how we're thinking about land law. And I agree with that at a high level. I think that when I look at the land space, I wonder why it's taken us so long to get to where we are. And I think we do need to shift the ground quite radically. There's so much that one can do, and we are bound by stare decisis, and stare decisis is a principle that is central to the rule of law in South Africa, which is a founding value. So as a lower court, there's so much one can do until matters ultimately get up to the Constitutional Court. So if I may use this opportunity, now that I have the audience, to suggest to the Constitutional Court, that there's a critical need to have a look at some of these issues. They really do need to be scrutinized, I think, carefully. The one area where I have, I believe, managed to make some headway is in the area of cattle and grazing. And this is an issue which we canvassed at some length in the previous interview. And I know that in the case, it's the one matter where I have been overturned on appeal. And as I understand it, that case, I don't know what the status of it is, but that there are processes, those parties are seeking to go to the Constitutional Court. So it may be that there's an opportunity coming up soon, whether it's in that case, I don't know what the court will say, but whether it's in that case or in another case, we really need to rethink how we think about cattle and land. And that's precisely because of the connection between cattle dispossession and land dispossession in this country, which what we see in the court is ongoing. It's that colonial legacy of dispossession is ongoing, and that requires full frontal re-examination of the common law and how it applies in the context of land law. The issues around labour tenancy are very troubling as well, and that not only invokes concepts around community and labour tenancy, it also invokes the cutoff date. So the cutoff, everyone knows the Constitution refers to 2013, the date of the Land Act. Especially in the world of labour tenancy, many people were converted through the stroke of a pen to become labour tenants when titling happened in the late 19th century, sometimes without their knowledge. So how we think about, and that can impact in how whether one's even viewed as a community. This is a live issue before me now, so I can't go into it in much detail, but the issue of what is a community and how labour tenants are understood in that space it's a deeply troubling question that I believe needs to be looked at closely by the courts. I'm going to have an opportunity to do that now, and I've just heard argument in a matter on that. But the issues that you raise, Commissioner, are obviously they're large issues. I would love to talk about them all day. I don't think I have the space.
We don't have all day.
But yes, I agree that there's real space to shift our jurisprudence into a more progressive jurisprudence.
No, I think that answer suffices for present purposes. It's just whet our appetites enough. Discussion for another time at length. Just to round off on your CV, Judge Cohen, I sold you short because I did not mention the many publications you have under your belt from your other life as an academic and legal practitioner. You've listed 12 publications on diverse subjects, ranging from witchcraft to a critique of the draft National Prosecuting Authority Bill of 1997, and of course, which I overlooked, a review on sexual harassment in the workplace. Interesting. Do you still write? Do you have the time?
I have to write judgments. Indeed. I have to clear my desk on an ongoing basis. I'm not writing academically at the moment. I'm focusing on my core judicial functions, which are now also including at this stage, at least, administrative functions. So I haven't had the space to write for some time. Yeah. And I haven't yet found that voice as a judge. So I used to write as a practitioner, which gave me more space to express my opinions. As a judge, you have to be more careful. You can write, obviously, but I haven't yet found that voice, but I hope to do so again at some point in the future.
Yeah, I hope you do too. All right, that brings us, there is another hand, Commissioner Nungonyen.
Good morning, Chief Justice. Good morning to the commissioners. Morning, Judge Cohen. A pleasure to see you.
Good morning, Commissioner.
I'm impressed by your presentation. But the point I would like to raise with you is that in that Macau case, which is a complex case involving Northwest, Limpopo, Mpumalanga, and Gauteng. And all those that were involved there were really impressed, including myself, representing Contra Lesser. I'm sure you're seeing me for the first time. But the question that I would like to raise with you is how do you really balance the principles underlying customary law as well as those Roman Dutch law? Because in all the judgments, we were all impressed about the manner in which you navigate these things. Thank you very much, CJ.
Thank you, Commissioner. I find the interrelationship between customary law and common law to be one of the most interesting features of our law. And it's quite difficult. And again, it's one of the areas where we need more case law to explain how that works. But I suppose the starting point is the recognition that under colonial and apartheid rule, customary law was not accorded its proper place, and that one of the main purposes, and it was degraded, and it was distorted, and it was in profoundly problematic ways. And I think that the starting point is to see the Constitution as the point at which customary law must be given its proper place. It must it sits alongside common law, but it must be accorded its proper place. And that means that it has to be given far greater expression in how we think about land. That's the space that I'm occupying. Land rights, how we think about communities, how we think about community relationships. So I've been fortunate in my practice because I was exposed to a lot of these disputes, and I spent a lot of time with people hearing about how communities are constituted and how disputes are resolved, and I've learned a lot from what I've seen and from the cases that I worked in. And that allows me to bring that into my adjudication. I think it helps me to ask questions. I don't know the answers to everything, but I think it helps me to ask the right questions.
Thank you, CJ. I have no questions.
Thank you, Commissioner Ngunyan. That brings us to the end of your interview, Judge Cohen.
Thank you, Chief Justice.
Thanks for presenting yourself for this interview.
Thank you, Commissioners.
Yes,
thank you, Chief
yes.
Justice.
Good morning, Judge Mia. How are you? Oh, your mic is off. Just switch it on and bring it closer to you. I know you are very soft-spoken.
Okay, thank you. Good morning, Chief Justice, and good morning, Commissioners.
Thank you.
Good morning, Judge President. And
this is not your first time before this commission, is it?
no, it isn't.
So you know the
Yes.
you know the drill. Okay. You obtained a BA and LLB from the University of Cape Town in 1989 and 1995, respectively. And then went on to the University of the Western Cape, where you did a master's. Was your master's in human rights?
It was in children's rights and criminal constitutional law.
Oh, I'm confusing you with another candidate. All right. You have a long and illustrious career, judicial career, that starts in January 1996, where you worked for the Legal Aid SA. You were there for a year?
Yes.
Then your CV says, your questionnaire says professional assistant at one, I assume, attorney's firm. Did you do articles? What exactly did you do there?
I was a professional assistant. CJ, my articles were served at Legal Aid.
Oh.
Yes.
All right. But you were there for a very brief stint and got a job with the South Peninsula Municipality as a legal advisor.
Yes.
Didn't stay long there either.
So the reason why I left was because of an uncomfortable experience. The legislation had just changed, so you couldn't be discriminated against at that stage for being pregnant. I'd been appointed and I was pregnant. When I went for the interview, I was pregnant. And when I was appointed, I think at that stage, the municipality tried to withdraw the offer. HR said, no, you can't. But during the brief month that I was there, I was subjected to a lot of comments about being pregnant and being barefoot and staying at home. And during that month, I'd received another offer from the Department of Justice, and I indicated that I was pregnant. And when I considered the treatment I was receiving at the municipality in terms of the comments being made and the discomfort I was experiencing as a result, I made the decision to leave the municipality and go to the Department of Justice, where they were comfortable with my being pregnant.
Yeah. Common experience of childbearing women in many areas of the workspace, unfortunately, even to this day. So you went back to the Department of Justice and did a whole lot of things there, family advocate, became a magistrate, until your appointment as a judge. Well, you started acting in 2009 and was finally appointed permanently when?
In 2020.
2020, yes. After many years and many stints, acting stints in between, in the South Gauteng High Court. Oh, you acted in various divisions, actually. Western Cape, Gauteng, and the Free State.
Yes, I started in the land claims court. I went to Cape Town, to Gauteng, Bloemfontein, and then back to Gauteng.
Right. And by then you had risen to the position of senior magistrate in the magistracy.
Yes.
All right. When did you start working in the land claims court?
In 2009, I started in the land claims court. And
your acting stint was in that court?
Was in that court, and I stayed there for a period of 18 months.
When were you seconded after your permanent appointment to that court?
It was in, so I served a period.
Sorry?
So whilst I wasn't seconded, I served a period in the land claims court for a term in 2020.
2020.
Yes.
And have you worked in that court since?
I spent a month in the land court in September, this past
September.
Yes.
And that's the extent of your experience in that court?
Yes.
Okay. I have no doubt you are an experienced judge. You have the advantage of having acted in various divisions. You know the common challenges facing the judiciary. And I imagine that in your time in the land court, you have been able to pick up whatever challenges the court may be having, and hopefully have an idea on how to solve, if possible, some or all of those challenges. Would you tell us what you've identified as needing to be improved, changed in the land court?
Chief Justice, I've sat in at the request of the Deputy President and the acting, the Judge President, the acting Deputy Judge President on meetings in the land court. So when there are meetings with the legal bodies, the meetings with legal aid, so the addressing of legal representation for parties. I've sat in on those meetings and I am comfortable that that is an issue that needs to be addressed. Legal aid has indicated how they wish to be brought in on those matters. And that has been indicated in terms of how they will be accommodated. They've indicated that it's not possible to have somebody at the court, but they can be contacted to be brought in. With regard to the backlog, I have assisted with case management meetings. There is a substantial backlog. I've indicated that even if I'm back at Gauteng, I'm willing, subject to Judge President's permission to assist with those matters. That is an area that requires preparation of matters because they need attention long before they're ready. With regard to case lines, that I understand has been rolled out, and those matters will be enrolled initially for Ester matters, and I understand that there's training in the Western Cape. With regard to training, I have been a facilitator for the South African Judicial Education Institute. So I bring that training skill that can be, that can support the Judge President in the land court. With regard to meetings with other stakeholders, I've sat in on that, on those meetings, and in terms of supporting the processes that need to be rolled out, I haven't sat in on the meeting with the special master, so I wasn't able to contribute to that. But with regard to the other meetings, I'm able to support the process in terms of rolling out, engaging with stakeholders, and contributing towards ensuring that the court runs effectively. With regard to engaging legal practitioners, that is an aspect that is ongoing. With regard to mediation and arbitration. That is something that I understand the Judge President will envisage bringing, identifying persons in due course. That is something that will be implemented at a later stage. So I think in terms of engaging with role players and stakeholders, I've had that experience in another life as a senior magistrate in the judiciary, and it's not something that is foreign to me. And in terms of bringing that skill, that is something that I can bring to this court, and I can support the Judge President in terms of that leadership, and to work with the colleagues in the land court.
Okay. Have you finished?
Yes.
All right. Have you had an opportunity to act in a leadership position in the higher judiciary? That is, as a judge, not in the magistracy now.
So in terms of a leadership position, not in a deputy judge president's position, no, I haven't, but in terms of taking leadership positions where I'm on a committee, yes, I do serve on committees in the court, and I'm a Hague Network judge. So in that regard, in terms of facilitating meetings, in that regard, yes.
How many judgments have you written as a judge? Or just on an estimate, it doesn't have to be an exact figure. Since you started acting in 2009?
I'd have to I think I would count over 100.
Mm-hmm. Any in the land claims court?
In the land claims court, I think there would be about 10.
Mm-hmm. Okay. And any of these judgments reported?
2.
Which ones?
So it was the Bapiring matter and the Farias matter.
All right. I know you're very active in the South African chapter of the International Association of Women Judges and do a lot of mentoring and gender advocacy. Can you just tell us a bit about that?
Yes. So at the present, I serve as the provincial coordinator in the chapter. There's a gender-based violence program that is run with that has just been launched with the Department of Education, and that is to sensitize youth around the issue of gender-based violence. The chapter has source funding to record a video which is intended to be screened to youth, and which is serves as the basis to facilitate questions, but to inform youth around different aspects of gender-based violence and to empower them around those aspects. Another aspect is the mood court program that we've participated in. There are programs around health and wellness, and around in December there's programs around awareness around AIDS and gender-based violence during the 16 days of activism. And then there's an initiative with the University of Johannesburg in order to launch a mentorship program. Apart from that, the chapter has its own mentorship program that it runs with in conjunction with universities where there are final year law students that are placed either with a judge or a legal practitioner, which runs for approximately 10 months of the year. And during that period, those law students are exposed to the work that the mentor that they are placed with, as well as they're afforded to sit in on lectures, and they're exposed to the practical aspect of the legal profession.
You are also involved with other civil society organizations such as NICRO, SANCA, and others, and the Africa Regional Judges Forum as well.
Okay, so NICRO and SANCA were previously. I am involved with the African Regional Judges Forum, and the African Regional Judges Forum has an annual meeting, and it intends to sensitize judges on different aspects. It started out with HRB. It then addressed a different topic each year, so also including HIV, but then moving on to raising awareness around the conditions in prisons, about the position of transgendered persons and refugees. And each year, there's an opportunity to consider the position of a person who has the actual experience. So apart from just listening to experts in the field, the forum seeks to invite a person who has had the experience. So by way of example, a person who has been incarcerated would give the experience, or a transgender person would give the experience, but judges from the continent who have written seminal judgments on the particular topic would also share their views. There have been persons who have been incarcerated, experience recovery from HIV and TB in our own prisons, who have tried to sensitize judges around the issues that they've experienced in prisons, and to help inform the position around sentencing and the circumstances. The Inspectorate of Prison has also addressed the forum on occasion, And I think our Judge President has also addressed the forum on one of the occasions. So it seeks to sensitize judges, and it's an opportunity for judges on the continent to share the experiences in terms of their judgment as well as to engage on those issues.
Okay. You wrote a published article, but that was before you started acting as a judge. I suppose the bench has taken that out of you. You wrote on the impact of cultural values on maintenance orders.
Yes, that was very early on when I was on the district court bench.
Why have you not written again? Lack of time, I suppose.
Yes, I think with my involvement in the SSCI WJ and on the bench, I think there just hasn't been time because I've moved a lot, changed between the positions, going to the High Court, coming back, and organizing, being in different positions through the organization. There's been a lot of movement.
Okay. Thank you, Judge Mayor. I'll hand over to your JP, Karelse, to
Thank you,
questions
Chief
to you.
Justice. Judge Mia, you and I know each other for many years. We've worked together as colleagues, and I also know that your history from your CV speaks for itself. You've always made yourself available to work with children, vulnerable groups, and I know that access to justice from your CV as well as the area of gender equality is very close to your heart. I also wanted to just be clear about something, is that the circumstances didn't allow for you to be appointed as an acting DJP at the Land Court. I'd only been appointed from the 1st of June. But I did give you opportunities. I invited you to, because we 3 judges, permanent judges, 4 with myself. It's a very small court, the tasks are huge. And my approach was that the court would be run by a team of judges. So I invite all judges to attend meetings, keep them abreast of what's going on, and consult with them about problems and challenges that the court faces. So you have been involved on a level of administration, is that not so? Okay. Now, knowing the operational challenges and that the Land Court currently faces, in relation to its logistics, its human resources, financial resources. Just for record purposes, the Land Court was allocated a budget in April of 500,000 Rand to do restitution matters and to travel throughout the country. Yeah, and of course our caseload, which you did manage. Tell me, in your view, the Land Court is in a critical period of transition. It's a newly established court. What is your vision for this newly established Land Court, given our challenges, our difficulties?
I think the budget is going to determine the extent to which the court can fulfill its mandate. However, there has been engagement with the role players, and to the extent that there has been enlistment of pro bono practitioners, I think that assists. I think that the issue of the backlog being addressed in terms of the historical backlog, that is an issue that can be addressed in the interim in terms of case management. So for the present, I think that what needs to be determined is the process going forward in terms of dealing with the historical backlog. With regard to the matters in terms of ESTA, I think there's already been training in that regard. So going forward, to the extent that that needs to be rolled out further, that can be addressed. The issue with regard to going, the court online project is limited at this stage. Once there is clarity on how successful that is, I think that will be rolled out. My view is that court online should be rolled out completely to all matters to the extent that it is feasible for practitioners, especially with regard to applications. Opposed motions can be dealt with virtually. Unopposed matters can be dealt with virtually. And having sat on some of the case management matters, practitioners are requesting that matters be so with interlocutory applications and opposed motions, there's a request that those matters be dealt with on a virtual basis so that a cost can be saved. In terms of traveling, I'm not saying that it's not necessary to take the court to the provinces. That is something that must happen in order to make the court accessible to people. But I think that where it's possible, that matters can be dealt with, where matters can be dealt with virtually, that that opportunity is pursued given the limited budget.
Okay, just for record purposes, our court online, the only area that's excluded are unrepresented persons. We've now taken it across to all applications, and the only persons, because of financial constraints, unable to upload, don't have the infrastructure. We haven't extended court online to unrepresented persons yet.
So to the extent that they are unrepresented persons, Gauteng has a facility where persons are assisted, and to that extent, the land court can look at, and perhaps we need to look at how that can happen with regard to unrepresented persons and the feasibility of it. Does it happen at the court, and where those unrepresented persons are? If they're in the provinces, how that happens and whether that is feasible or not. But to the extent that it is, they are in the within the precincts of the court or in the same province, we could roll out a service similar to what happens in South Gauteng High Court, where they are assisted.
Thank you. Can I ask one last question, Chief Justice? Yeah.
Hey, you are the head of that court, so you get a larger share than the rest of us.
Mike,
please.
The debate and the discussion around sexual harassment was raised by the previous candidate, so I took it upon myself to engage with her. And I'd like to ask you, Judge Mia, the same question, and it's tied to your leadership as well, your leadership abilities. If you were to receive a complaint as head of the court, DJP in this instance, of sexual harassment, how would you deal with it? And are you aware of any judicial policies around the question of sexual, or policy relating to sexual harassment in the judiciary?
Thank you, Judge President. I'm aware of a draft policy that has been circulated, at least in South Gauteng. The draft policy indicates what the position is. It describes sexual harassment. It gives definition to the term. And in terms of the policy, it requires that the matter be dealt with seriously, and it requires that the matter be referred to the JSC for investigation.
Thank you, Chief Justice.
It's just a correction, Judge Mia, and it's not your fault. If anything, it's my fault. There is actually an approved sexual harassment policy that is yet to be disseminated to the rest of the judiciary shortly.
Chief Justice, I do recall that there was a policy signed before the previous Chief Justice left. Yes, but because it wasn't circulated, I can't speak to that. So I'm just speaking to the draft that I was aware of.
I was just placing that on record. It doesn't reflect on you.
Thank you.
Commissioner Nukes?
Thank you, Chief Justice, and good afternoon. Good morning.
Good morning, Commissioner.
You are applying for the position of the Deputy Judge President, meaning that you will be expected to give support to the Judge President. Can you tell what is the vision, as you understand, of the Judge President for that division? I mean, for the land court, which you will be supporting and you fit yourself to. What is the view? What do you understand is the vision of the Judge President for that court?
So I understand the Judge President's position is to give effect to the legislation that supports that court. So it is with regard to addressing the backlogs in the court, giving effect to land restitution, dealing with those cases. In terms of the Judge President's vision, from the time that I've been there, she's been the way she works is that she's been inclusive. She has reached out to stakeholders in terms of addressing the manner in which she will be dealing with issues in the court. So she seeks to address the issues in terms of dealing with the backlog. She has the vision that she wants to ensure that there's access to justice in dealing with the legislation and the new act that has come into being.
Sorry, Judge. I think you are guessing this. I'm sorry to say. It seems that this is what you think is the vision of the JP. Have you followed up with the JP? What is the vision? Because you are going to support. The reason I'm asking is because we are a support to the Judge President. You have to give support. Do you understand? Do you know? If you don't know, don't keep what you think it is. Have you discussed this with him? Do you understand what she wants to happen in the land court? Are you aware as a fact?
Commissioner, to the extent that I've sat in on the meetings and she has discussed what she wants to see happen in the court, that is what I'm speaking to.
Okay. Then my second question, because I was clarifying. Now, I understand that as we are applying for a leadership position, one of the basics, you must demonstrate intellectual leadership to steer, meaning that which we can see from your judgment. Which of your judgments would you say, for purpose of the land court, and so far as the land court is concerned, and in particular, the law that relate to the issues of land, that you can say, this is my judgment. What judgment can you take us? Because this that we are referring to, there's nothing that comes up from my perspective. Which judgment can you point and say, this is the judgment that seeks to transform the whole question of land redistribution, restitution, what? I mean, which judgment would you say, this is a judgment that I present, would say I can steer the land court as a judge, as a leader, sorry.
Yes, I don't think I've sat on a restitution matter recently. And the two reported judgments are the Farias matter and the Bapiring matter.
No, Judge, what I'm trying to say, sorry to interrupt, I'm done now. But all what I wanted to say, you say there is this judgment. In this particular judgment, this is what it was about. And this judgment addresses this particular principle in terms of acceleration of land distribution in the interpretation of the giving effect to the Constitution, Section 25, or like a judgment that will tell us that this is the judgment, this is the principle. What is the situation? This is the principle that arises from that particular case of your interpretation. As a leader, this is a direction at the level of your intellectual leadership. That is, as a leader of that court, as a deputy judge president, you will have to take responsibility, particularly in some complex cases.
Okay, then I'll refer to Farias. We had to determine the value of. It was a restitution matter where the land was restored, but the value of the land had to be determined, the compensation had to be determined, and the money value had to be determined over a period of time. I was required to determine that. I considered the different methods that were placed before me, and I made a determination of the appropriate value that was to be determined.
Thank you, Chief Justice.
Could I just follow up on that so that I don't have to raise my hand? Judge Mia, thank you for the answer you've given to Commissioner Noches. I want to go back to the Bapiring judgment.
Yes.
I understand it's a 2010 judgment.
Yes.
And that's 14 years ago. And it might be that your views have evolved over time.
Yes.
But it was a singular judgment because I think you gave it with the judge. Geldenhuys, yes, who was regarded as a doyen of that institution. But it was regarded, I think even at the time, as a very retrogressive judgment, taking the law backwards, because what it did is it's to put the issue of feasibility at the beginning of the trial. And the way it approached feasibility, even at that stage, was viewed by many land lawyers as anti-transformational because it required an assessment into whether a community could take up a particular commercial space of land. And if the answer to that question is no, then a priori, restoration is not feasible. And therefore, the debate should be, should they get money or not? So I just wonder whether, in the light of what has happened in the last 14 years on land jurisprudence, you would still hold on to that view, which is one of the reasons many land lawyers have said we've had a very constrained land reform coming from judges, not from the executive. Whether you think that that approach of putting feasibility, in a sense, as a cart before the horse, before you even look at whether there is an entitlement to restoration, whether that approach is correct and whether you would persist with it in the light of what you know now. I give some admission that it's been 14 years and maybe you were also new in the space and there's a lot you've now learned.
Commissioner, yes. I probably would write that decision differently. I recall at the time that I had posed particular questions to enable me to consider a different position at that stage. And there was very little forthcoming at that stage to write it differently. But yes, I would invest more in order to look at it differently.
And of course, Mapiring is the judgment that brought, not your judgment, but the Mapiring story is the story that brought disrepute to land reform. Because it's the case where the government paid R1 billion to white people in Mpumalanga when it should have paid 300 million rands. But the starting point was your judgment, and that's why I'm thinking about, well, maybe it was 14 years ago and maybe things have moved on, but thank you for your answer.
I don't know if you want to say anything in response, Judge May.
I think that, yes, there's always an opportunity to look at the context differently. And with the passage of time, one is able to review and to reconsider. And I think that the SCA did look at that decision. And so that has been instructive.
Thank you very much, Chief Justice. Good day, Judge Meyer.
No.
Mia, sorry.
Sharing, that's me.
Good day. Deputy President.
I think the mic is off. Sorry, I can't hear.
I don't know what's happening. It was on. I just want to refer you to page 13 of the paginated bundle. My question relates to your acting appointments in the Land Claims Court. Paginated bundle, page 13. Of your section.
I'm sorry, what did you say, Commissioner Hassan?
I just wanted to clarify, because I'm also looking for the same paginated page 13. The one we have, or the one I have, is still the CV on paginated, page 13.
1-3. Yes.
There are two bundles, and yeah,
No,
it's in one of the bundles.
it's a section that relates to her forms, her application. So the first section related to Judge Cowan, and the second section of the bundle relates to Judge Mia, and it's page 13.
Where her CV is.
Sorry?
Where her CV is.
Yes.
All right. Have you found it, Judge Mia?
I found it.
All
Thank you, Chief Justice.
Thank you very much. Now, about line 1, 2, 3, from the top of the page. Acting judge from 11 to 31st December 2010, 18 months. And then on top, second line, on top you have got May 2009 to October 2010. What, I just want to establish exactly how many months did you spend or as an acting judge at the land claims? Because 11 to 31st of December 2010, it's really not 18 months.
So the period.
Sorry?
The period, so the second line and the third line, the period of 18 months is calculated. Sorry, the error is my error.
Sorry, it's a mistake.
It's May 2009 to October 2010 and December 20.
So I take it you meant to combine the two acting stints,
So
and
the
they both
two
make up 18 months.
Line 1, line 2 and line 3. The period is indicated on line 3 because there's no period indicated at the end of line 2.
Yes.
My question relates to the number of judgments that we have penned since joining the land claims court. And there was a question that was put to you by the Chief Justice regarding the number of judgments that you had written, and you indicated that we have got 14 judgments in the land claims.
I said approximately 10.
10, okay. But they are not indicated on this form.
No, they are not indicated on this form.
Are they not important, or don't they have any presidential value, or what?
I've listed the two judgments that I thought were significant. The earlier judgments were, I think because of the time, because it was such a long time ago, I didn't include them.
And my last question relates to the jurisprudence of the Land Claims Court relating to the meaning of the community in terms of the Restitution Act. As you are well aware that if a community claim is lodged, then the community must show that there were a group of people whose rights in land are derived from the shared rules determining access to land in common by such a group. Now, going through the cases at the Land Claims Court, it will seem to me that a number of claims have been dismissed on the basis that the community was unable to establish that they were a community at the time of disposition because of the intervention of farmers or the people that took over the land. How would you deal with a definition of the community? Because it seems to be very restrictive.
Especially because the community itself is disrupted by colonialism.
I think it's based on the evidence that is led. And I think when I started in 2009, what happened at that stage is the LRC had applied to lead evidence of elderly members of communities because the view was held that with the passage of time, that evidence would have been lost because of the passing of those community members, but the evidence would have been retained had the proceedings been captured in terms of the oral evidence. And I think that is important in terms of capturing that evidence in terms of being enabling the court to make a determination with regard to what the community's, the history of the community's use with regard to the land.
Thank you, CJ. No further question.
Thank you, DP. Commissioner Mtweni Tsipan. Any further questions for the candidate, colleagues? Oh, JP Mlambo, sorry.
Thank you very much, Chief Justice. Good morning, Judge Mia.
Good morning, Judge President.
There are a number of projects currently ongoing at the Land Court. The rolling out of case lines, the historical cases project, the engagement with communities using Causa. Are you involved in any of these projects?
Judge President, whilst I was there, I sat in on meetings relating to those projects, but as I'm not sitting on that court, I have not, I'm not allocated to anything specifically, but I have played a role in engaging whilst I was there.
All right. What do you think are the current establishment needs judicially, that is judicial establishment needs of the court?
So if the position of the Judge President and the Deputy Judge President were not factored in, there'd only be two judges, I think there would be a need for at least another 6 judges, between 6 and 10 judges. And I think if there are judges appointed on an acting basis, that judges can be appointed progressively on a permanent basis.
My last question. What is your leadership philosophy since you're applying for a leadership position?
Judge President, I think the manner in which I work at present is inclusive on the committees where I work in Gauteng, and I think I'd bring that over to the land court. In my positions outside of the judiciary, where I work in the SSE IWJ, it serves to give the opportunity for people to support people and to give the opportunity for people to contribute. So I would be inclusive in that. Similarly, in this position, I think the Judge President has from the outset indicated that her vision is inclusivity. I subscribe to that, and I think I would allow for an opportunity where there'd be inclusivity, notwithstanding that some judges are in different provinces. I think we are able to address that with virtual participation and to still ensure that there is inclusivity and contributions, and that all judges are able to contribute to the growth of the land court.
Thank you, Chief Justice.
Thank you, JP. Any more questions for the candidate? Prof. Marumachai?
No, nothing from my side, CJ. Thank you.
Thank you very much. Judge Mia, we've reached the end of your interview. Thank you very much for making yourself available for the vacancy, and wish you all the best. You're excused.
Thank you, Chief Justice, and thank you, Commissioners.
Colleagues, we're running behind time, but I think we can still make it with careful management. I propose that we take a short comfort break and perhaps bring back our teas here so that we can be back in exactly 10 minutes. It's 20 to 12 now. Let's be back by 10 to 12, please. Sesto.
Yeah, but you're right.
Recording in progress.
Good morning, Judge Ngobe. Okay, are you comfortable?
Yes, I'm comfortable.
Good. And well, I hope.
Yes, I'm very well.
Good. You have a string of academic qualifications.
Yes, that's true.
A BUris and LLB from the University of Zululand. Is that ongoing?
Yes, yes.
Then you did a postgrad diploma in environmental law in the University of KwaZulu-Natal.
University of, yes, KwaZulu-Natal.
And later, a master's.
Yes, a PhD degree, which was converted into master's later.
Or you registered for a PhD degree?
And afterwards, it was converted, and I did the thesis and then converted into master's.
Oh, I see.
Yes.
What was your thesis on?
It was on the sustainability or sustainability of what we call environmental law, sustainable development, achievement of sustainable development in environmental law.
All right. You joined the Department of Justice as a court interpreter. I'm just looking for your your application form. Thank you. You joined the Department of Justice, where you took the usual trajectory, which is almost similar to mine. You started as a court interpreter.
Yes.
In 1982.
Yes.
Did that for a year, then became a prosecutor for 2 years.
That's correct.
Then you became a magistrate, quick ascension through the ranks. Magistrate from 1986 until 2013.
That is correct.
And in 2014, you were promoted to regional magistrate.
Yes.
And then you started acting as a judge shortly thereafter. Well, from 2016.
Actually, I had already started acting as a judge in the land claims court from 2006.
Oh. Yeah. And how long were those stints? Just take me through them.
I would act for about 3 months, 6 months at a time. But then in 2016, I then acted continuously until I was appointed.
Oh, I see. In the land claims court.
In the land claims court, yes.
Then you became an acting judge. You were appointed as a permanent judge in 2022.
Yes.
All right. To date.
Yes.
You've written a number of judgments, I see.
Yes, I've written a number of judgments. The most important one is the one dealing with the appointment of the special master. The Mwelase judgment, which is well known, yes.
It was upheld by the Constitutional Court.
Yes, it was upheld by the Constitutional Court after it was dismissed by
the SCA. Quite a feather in one's cap. And I recall presiding in an appeal against your judgment in Aquarius. This was Platinum Limited, and we upheld you, and it was a sweet judgment you'd written there.
Yes, thank you.
You write well, Judge Bolas. I'm calling you Judge Bolas and now Judge Nobe.
Thank you.
All right. You don't have any reserved judgments, do you?
I have only one.
Well, older than 3 months?
No, not older than 3 months.
Okay. You are applying to deputize Judge President Karelse in the land court.
Yeah.
Will you just tell us as concisely as you can what plans you have for that court, if any, if there are any challenges you've identified that need addressing and so on?
Chief Justice, the ultimate aim here, ultimate aim of all of us and all of the judges of the land court is to achieve and to restore the land, is to help the people to get back their land. People are lamenting about that dispossession which occurred in the past. People want their land back. So I think in whatever we are doing, we must place in mind that the ultimate aim is to get the land back to the people. And if we are the judges of the land court, we must be aware of what the situation is like outside and how people feel about that dispossession which occurred in the past. People are looking upon us to redress the injustice of the past, insofar as the allocation of land is concerned, insofar as the restitution is concerned. Maybe those of us who are familiar with the judgment in Daniels versus Scribante, they'll have been aware of the quotation which is quoted there in the introductory part of it, quoted by Justice Matlanga. A statement which is quoted from the speech which was done by an old man who was known by the name of Petros Nkosi in the former Eastern Transvaal. I think most of us will be aware of that quotation, which shows how people out there feel about the restitution and how people out there feel about dispossession of their land. I'll just briefly state that quotation. He says, this man says, the land, our purpose is the land. That is what we must achieve. The land is our whole lives. We plow it for food. We build our houses from the soil. We live on it, and we are buried in it. When the whites took our land away from us, we lost the dignity of our lives. We could no longer feed our children. We were forced to become servants. We were treated like animals. Our people have many problems. We are beaten and killed by the farmers. The wages we earn are too little to buy even a bag of meal. We must unite together to help each other and face the poors. But in everything we do, we must remember that there is only one aim and one solution, and that is the land, the soil, our world, unquote. So as we are here, working as the judges of the land court, we must be aware of these comments of people, what people are saying there outside, and we must strive by all means to assist them in getting back their land. We must strive by all means to do away with the injustices of the past, to redress the injustices of the past. But what are those injustices I'm talking about? I'll give 4 scenarios. My experience in cases. I was reading a report by one expert who was employed by the landowners. This expert is giving me a report from the information obtained from the archives. This expert says there was a Second World War. In the Second World War, people were recruited to go and fight in the Second World War. Blacks were recruited, whites were also recruited to go and fight in that war. But when the war was over, people returned back to South Africa and they were compensated for their participation in the war. But what was the compensation? A white man was given a farm, which was given to him free of charge. It was given as a grant. What was the compensation for the black man? Black man was given a bicycle. The black man was compensated with a 3-legged pot. A black man was compensated with an overcoat. And he was brainwashed. He was told that he got more than the white man. The white man only got land, something which is useless, only soil. And you got 3 items. The white man only got one thing. What you got is more than what the white man got. That is one example of the injustices which happened in the allocation of land. The second one, again from one of my cases, this witness says they were told in the morning that the government will come here in the afternoon. The government is going to demarcate the boundaries. They waited for the government. They didn't know the government. In the afternoon, a white man came on horseback. He stopped the horse there and he said, on my right is a white land, on my left is a black land. If you are on the right and you are not white, you must vacate that land and go to the left-hand side of where I'm standing. You can only come to this white man's land if you are coming to work for the white man. That is the second scenario. I have a third scenario. This witness says they were bathing at the river one day. They were naked. They had just washed their clothes and allowed their clothes to dry up. Once they were naked there, waiting for their clothes to dry up, white people came with dogs. They set dogs on them and chased them away from that place and told them that this place belonged to a white man. As from today, we are no longer allowed to be here. They ran away like that, naked like that. And they never went back to their land. That is the third scenario. The fourth scenario, also from one of my cases, which I've been told by a witness. He says one day, a white man came and called them. I think I mentioned this in May when I appeared before this Honorable Commission. White man came, he called them. He said, come. Go over the mountain, go and join other baboons. Go and join other baboons over the mountains. That was the last day they were at that piece of land. They never went back to that piece of land again. They were chased on that day. Those are the injustices. Even the Land Court Act, the present Land Court Act speaks about the redressing the injustices of the past. But how are we going to redress these injustices? Maybe that is the question now, which must be asked. What are we going to do? We, who are the judges of the Land Court, we must not be afraid to give judgments which are robust. We must not be afraid to make orders which are unprecedented, like the one I made in the Mvelase case. It is described by the special master, that judgment, he describes it as the first of its kind in South Africa. First of its kind in South African judicial system, and most probably the first of its kind in the entire African continent. Although it was difficult because it was seen as the infringement of the separation of powers principle, but eventually people were able to get justice because the Constitutional Court came to their rescue. They were able to get justice. Those labor tenants who had been waiting for years, about 20 years, waiting for their applications to be processed so that they could get back their land. At least there is now some improvement with the appointment of that special master, which I ordered. There is some improvement. On the 8th of December 2016, when I signed that judgment, when the judgment was handed down, there were about 20,000 cases which were outstanding of labor tenants which had not been settled. But with the appointment of the special master, at this present moment, there are only 9,101 cases which are outstanding. He's making some progress, although there will be problems. In most cases, coming from the department, because it was seen as if the special master is interfering, because the order was that he must get involved even in the budget itself. So that was seen as being the interference in the work of the department. Those are the things which we must do. That is what we must do. We must give judgments which are robust and make orders which are unprecedented. The other challenge is the accessibility of the court. The court is not accessible to the people. We must make sure that the court is accessible to the people. We must take justice to the people where people are. We must not expect people to roam around looking for this court, because most people do not even know where the land court is. I have seen this when I go to the High Court to do my High Court work. I have seen cases which should have been taken to the land court, but they were not taken to the land court, they were taken to the High Court. Why is that? Because people do not have confidence in this court. And you ask counsel, but counsel, why is this matter here? Because it is supposed to be at the land court, and you get all sorts of reasons. But you can see that the reason is because they did not want it to go to the land court. Now we must try and instill confidence in the members of the community. People must see that this court is working for them. It is their court. It is not our court. It is their court. Well, I know that there are problems about the budget. Everybody is complaining about the budget. All the departments are complaining about the budget. But I think now the time has come. Maybe we shall discuss it with the president, with the judge president here sometime later. Maybe the time has come for us to decentralize the land court. Like in my case, I'm sitting in KZN, I'm sitting in Durban, I'm working there. If there is a judge who is coming from the Eastern Cape, I know Judge Flatella is from the Eastern Cape, who can take Judge Flatella and place Judge Flatella at the Eastern Cape High Court, at Mthatha High Court or any other High Court, where she can be nearer to the people, where she can be nearer to people whom we are serving. If there is a judge who comes from Mpumalanga, we must have a judge stationed there in Mpumalanga. Because even though we are complaining about the budget, but if we decentralize the court in that manner, I don't need to sleep at the hotel. I take my car and drive to the place where the people are. I don't need to fly. I'll take my car and drive to where the people are. Even if they are coming to me in chambers, or in Durban where I have my chambers, they are not going to travel a long distance because they are from there, from the province, and I'm also from there. Other challenge, we must see to it that we train the magistrates because we deal with them. Automatic reviews. Sometimes we criticize them only to find that we criticize them because they have done something wrong, but they lack training. They have not been trained in that field. So we must tell them what we want. Already, we are training stakeholders already. Well, the training of stakeholders is good, but one might not be very comfortable with it, but it is good. Stakeholders will involve attorneys, advocates, and legal aid people, okay. But sometimes it may look like it is inappropriate for a sitting judge to tell the attorney how to litigate. Because they can quote you sometimes when they're in court. They can quote you that, but who said it is done like this? So maybe we must rethink that sort of training and maybe make more use of retired judges and retired magistrates, those who understand ESTA, the provisions of ESTA, perhaps. And I have noticed, reading the 10th report, the 10th Lamosa report, in the Eastern Cape, they've come up with a system of traveling around, looking for those people, looking for the claimants who are no longer proceeding with their claims. So they are trying to trace them. They have a bus office. They are going to take this bus and travel along the province, looking for these people and verifying the people who lodged their claims. I'll talk to the JP and see if we cannot get a lift in that bus. And if we cannot get a lift in that bus, so that we also become part of that tour, so that we get those people who filed their claims, but who are no longer pursuing their claims. I think that is a very important step to take. Because we see that there are claims which are still outstanding, which have not been finalized, even with the Lamosa cases. Last time when I appeared before this commission, there were 6,139 cases which were outstanding. Well, there have been some movement. They did about 144 as of today. From the time I appeared here in May or April, they've done about 145. They are remaining with 5,994. Now they've given us a report which says that it is going to take them 30 years to finalize those matters. They've given us a report which says that it is going to cost them 172 billion rand to finalize those matters. But if you look at their problems, at the challenges which they have now, mostly it's lack of training, because they say members of staff, most of them, they do not know how to do the mapping exercise they cannot interpret the maps. But at the same time, they say the solution to the problem of short staffing is to get more staff. But now I'm asking myself, get more staff to do what? Because the staff is not trained. They don't know. How can you get more people who do not know how to do the mapping exercise? Maybe to solve the problem is to get them trained, at least by the Office of the Surveyor General. Because people from that office, they know exactly how to interpret the maps, and they know exactly how to conduct the mapping exercise.
I'm going to give you 5 more minutes just to round off on this vision,
Yes.
if you need it.
Yes, I'm coming back to the issue of the historical cases which are still outstanding. We are trying by all means. That is one of the problems we're having. We are trying by all means to solve it by the appointment of those attorneys. We have come on board to assist, but it seems that we must change the strategy. Seems that we must change the strategy now, because in the spreadsheet there's a space which requires the reason why the matter has been stagnant, why the matter has not been moving on. The auditors or those attorneys who are working on that, they have left the space blank because they don't know the reason now. Now, that was the reason why we came up with this project, that we must identify the reasons so that we must attend to them. But if we are going to leave the space blank without the reasons, then it means we have another problem. Maybe we shall have to devise another strategy and see what we can do. Thank you, Chief Justice.
Thank you very much, Judge Ngobe. Have you played any leadership role in the land court, and by that need not be a formal acting leadership position? I include working in committees and any projects of the court.
Not formal acting role, but we are working together as the judges of the land court. We are working together. The JP used to invite us in whatever project she's involved in. We do it together. I've just referred to the training of the stakeholders. We have done that together.
Oh, you were involved in that training?
I've been
All
involved.
right.
I've been involved in that training. Yes, I've been involved in that training as from the time of Judge Baum, when the Judge Baum was still alive. We were involved in that training, and even now I'm involved in that training.
All right. You will turn 67 just a few days before this coming Christmas. And for some, and I'm sure the millennials and Gen Zs among us, that may be an issue. Should it be? Should we worry that how many years do you have? Maybe let me put the question that way. How many years do you have before retirement?
I'm 67 now, but
you can go on until 75?
I think I can go on until 75,
All
yes.
right.
I still have 15 years more.
We can do the math.
I can do
That's
a lot.
A significant amount of
In
time.
that time, I can do a lot.
Okay. No, thank you, Judge Ngobe. I'll give Judge President Karels an opportunity to put questions to you if she has any.
Thank you, Chief Justice. Good afternoon, Judge Nubi.
Good afternoon, Judge.
Okay. Judge Nubi, could you just, by way of example, give us one of your examples of your leadership over this time you're sitting in the land court in KZN? One example of your leadership while you were at the land court.
As I've just referred to the training of the stakeholders, we trained stakeholders. I think it was in February this year with Judge Mir. Judge Mir was there. Judge Cohen was there. Was also involved in the training of the attorneys and the legal aid people who were present there. Yes.
Now, there are several projects that are currently on the way at the land court. You mentioned the historical cases. Any other projects that you're aware of that you've been involved in?
Oh, the project of the rules, the new rules. I'm also involved in that one. I came down from Durban and I attended that meeting which we held, which was dealing with the new rules for the land court. Yes, I'm also involved in it.
Okay, I'm just surprised that you don't mention a very important project, the digitization of that court, the court online system.
The court online
Yes.
system. Yes.
How could you miss that?
Yeah, I missed it. Yes, the court online system, which I've attended, which was the training which was offered by JP Mlambo, was present.
Okay, but what's your vision? What is this going to do for this court of ours?
It's a very good thing. It's a very good thing because maybe sometimes it may curtail the traveling cost. It may curtail the traveling cost, and we don't have to travel all over the place. We can sit in our court or in the chambers and deal with the matters.
Sorry, don't confuse it. No, let's not confuse it with virtual courts. That's been happening since COVID.
Yeah.
I'm talking about what is the system? What will it bring to the land court?
Yeah.
What are the benefits?
Yeah, no, it will assist us to finalize matters quickly, first of all, to finalize matters quickly, but there might be some other problems now because with the people who are not educated and people from the far-flung areas, from the rural areas, people who do not access to the computers and the laptops, I don't know what they are going to do. I don't know. Maybe there is a way, because we are still getting training, maybe we are coming to that part of it. Because we're still getting training.
Okay, but those are the challenges. And like any new system, there will be challenges. What's your resolution for these challenges? With people don't have, they're not educated, they don't have a system in place. What do you think? So what are your solutions as the DJP? What are you going to say to me? Let's fix it. And how do we fix it?
Maybe the solution will be to deal with the attorneys, because in those instances where they are legally represented, we deal with that. Although they are from the rural areas, we deal with the attorneys. The attorneys will be having an access to the computer, and so we can deal with the attorneys. But it will be a problem if a person is not legally represented and it does not get a legal aid.
Okay. Judge Nube, you sitting in KZN. You sit there and the work is allocated to you. Now, I want to believe that as far as I see my role, very hands-on. You've got to be at the office every single day, working with the staff. It's a small complement of staff. Meetings are held, always in Johannesburg. They come to chambers. How do you see your role as a DJP, but sitting in KwaZulu-Natal? As you know, we're such a short number of judges. Tomorrow I'm in court. And likewise, you'll probably be in court tomorrow. That we not only do administrative work, we sit in court literally every day.
It is easy. With administrative work, we can do it online. But then if we do not do it online, I can always travel to the seat of the court. For instance, the acting JP, Judge Mir, was stationed in Cape Town, but she was the JP. She used to travel from Cape Town and go to Randburg, and she handled that court excellently. Although she was not stationed there.
And I think at the time there was just one, she was the only judge at the time. But I think you must agree with me that a DJP will have to be sitting in Johannesburg. There's no way that a person who could assist and to develop that court during its transition process can sit in another province. It's just not workable.
Yeah.
And to even use Judge Mir as an example, it was a different era. The court's jurisdiction has been extended. The historical projects have 6,000 cases. 2013 to 2016, there's already 1,000 cases that must be allocated. How do you see us dealing with this problem, with the logistical problem of where you'll be based?
Yeah, if there's a need to relocate, I'm willing to relocate. I have no problem with it.
Then I think I can't do it justice. I've got to ask you the same question I asked your colleagues previously, if you'll allow me, Chief Justice. If a complaint comes to you as the DJP of the office, one of sexual harassment, how would you deal with it? And do you know, are you aware of any policy in the judiciary dealing with this aspect?
In the past, when we were in the magistracy, when I was still a magistrate, there was something called procedure manual. We used to work on the basis of those documents which were called procedure manual. So I think here in the judiciary, we do not have procedure manual anymore, but we might be having a policy. We might be having a sexual harassment policy. Then we must follow the policy which is given to us as to what do you do in such a case. First of all, we must look at the case. If it amounts to a crime, what was done amounts to a crime, you report to the police, and the police will take over. Or if it is not a crime, then you sit down, you get statements from the people, get statement from the complainant, you get a response from the respondent, and sit down with the people and see if you can resolve the matter. Yes.
Thank you, Chief Justice. No further questions.
Thank you, JP. Any commissioner has a question? JP Mlambo.
Good morning. Oh, good afternoon, Judge Mobe.
Good afternoon, JP.
I just want to deal with your leadership philosophy. Are you able to share it with us? You are applying for a leadership position. What is your philosophy? What kind of leader can we expect from you?
Yes, my leadership philosophy is the same as my judicial philosophy. They go together. I subscribe to the philosophy of John Rawls. John Rawls' theory of justice as fairness. In my leadership role, I must make sure that I treat people who are working under me fairly and in accordance with justice. I must make sure that I have one-on-one discussion with people. If there's something wrong, I call a person to my office, to my chambers. We sit down, we discuss the problem. If there's a solution to the problem, we come up with a solution. My leadership philosophy is that I give people who work with me equal opportunities, if there are equal opportunities. That is very important. Again, in that philosophy of John Rawls says you can never do justice if we are not proceeding from behind the veil of ignorance. In other words, if you treat people, you must treat them equally. To treat them equally, you must proceed from behind the veil of ignorance. You must be ignorant of your color, you yourself. You must be ignorant of your color. So you must not favor any color. You mustn't know what color you are. You must be ignorant of your gender so that you treat everybody equally. You must be ignorant of your race so that you treat all races equally. So that is what I'm going to do if I deal with my people or the people who are working with me. It's wrong to say they are my people, they are not my people.
Thank you very much for that very illuminating view of what leadership should be. My second question. You mentioned a number of ideas that you think should be applied in the land court.
Yes.
Have you shared any of these ideas with your previous leaders or with your current leader?
The idea of training attorneys I have shared with Judge Mayor. And I shared with Judge Cohen when we were training attorneys in Durban. I shared that with them that it would sound that doesn't sound well. It might be inappropriate for a sitting judge to train attorneys. Yeah, I did share it with them, but they did not agree with me. So I still have to convince them again and see if we agree on that issue. Because according to me, I think we must make more use of retired judges.
My last question, my third question. The first candidate told us of that the rollout of court online, that the court itself has now taken up the responsibility of rolling it out to the communities. They've involved Legal Aid, they've involved the Community Advisor Office of South Africa, CAUSA, to assist in this regard. And she told us she's personally involved. Are you involved in that project?
No, in that one, I'm not involved in that one, but I know about it. I have followed it up. As I've just discussed the problems which I have encountered in that project, that there's a problem that the reasons why the cases are stagnant and they are not moving forward, they are not stated. So I have read those reports and I have read those spreadsheets. So we are going to work on them again and see how we come up with the reasons and how we can address the reasons for inactivity.
Thank you. Chief Justice, could I get an indulgence for just one more question, please? I don't want to be unfair on you. I don't know whether I heard you mention as one of the challenges of the court, the judicial establishment. Did you mention it?
Judicial establishment. No.
What, is there any challenge the court is facing from a judicial establishment point of view?
No, I did not mention it.
You didn't mention it, okay.
No.
Do I understand you to say you don't think there's a challenge in that regard for the court?
It might be, and it might not at the present moment, at this stage. I think at this stage we are still fine. But as time goes on, then we'll need more judges. But at this stage, we are not settled as yet. We're still settling down. And we're still working on the organogram. We don't have an organogram already. We're still working on the organogram. Once we get the organogram, then we know exactly which vacancy should be filled and which vacancy should not be filled. But at the present moment, I cannot say that we need more judges now. But as time goes on, we're going to need more judges.
Thank you, Chief Justice. Thank you.
Thank you, JP. Just tell me about this organogram you say you're busy working on. What is it about? Is it for administrative staff? Or?
Organograms, the office establishment. Because this is a new court. This is the land court is something new. So maybe we'll need more judges, so we'll know exactly the department will give us the organogram and say, this is the JP, this is the DJP, this is another judge, this is another on a chart. Put a chart on the wall, so we know which vacancy should be filled, which vacancy is not filled.
All right. Thank you, Judge. Deputy President Zondi.
Thank you, Chief Justice. Good afternoon, Mr. Mnguni.
Good afternoon.
Right. Now, you have applied for a position of a deputy president of the land court. Is that correct?
That is correct.
Now, do you understand the vision of your JP? The vision of your JP for that court?
The vision of the JP, I think it is the same as my vision.
No, it can't be. It can't be the same as your vision, because you must understand the vision of your JP, because you will be sort of providing a supporting role to JP, so you can't just go outside your JP's vision.
Yes, that is true. That is true.
Yes.
But how do we solve that? Is that
you don't have to solve it.
No, the JP will tell me what she wants. I get instructions from the JP. I don't do whatever I feel like doing.
Well,
she's the JP. She'll
sorry,
tell me.
I'm not at a stage of getting instruction. I'm at a very basic stage, understanding vision of the institution in which we'll be working.
No, at the present moment, I must say that I don't know her vision at the present moment, but she will tell me her vision and she will tell me how to go about achieving it.
Okay, thank you.
Commissioner Matolo Dlepo, follow up?
Yes. Yes, Chief Justice.
Okay, ask your follow up before I call on Commissioner.
Now, Justice, in relation to the answer that you gave to the DP, all the things that you have been telling us about the land court and its intention to implement, were those your ideas and not the ideas of the JP and the support that you'll provide?
They are my ideas, not the ideas of the JP, but they are my ideas, the ideas which I'm prepared to transfer over to the JP and see if the JP accepts them or not.
Commissioner Otis?
This is now follow up. Look, I heard your plan. How does the plan that you have outlined to the JSC about the court link up with the vision of your JP and the court? You have outlined your plan, what you say is the plan. This is what we are convinced you want the JSC to consider or recommend you on the basis of. How do you align that with the JP or the court's vision?
As I have said, my vision, I'll give it to the JP, is the vision which I'm going to place in front of her.
Now,
and see if he agrees. If she agrees.
What the difficulty is, Justice, is that you have not conducted any research about your own court. What is the plan of the court? What is the strategic approach? And you come before the JSC, you don't understand your own court, because if you can't understand what the JP or what the vision of that court is, you can't even begin to present a plan, because the plan you present must align with what the court's direction is.
So I think there can be no any other vision apart from the vision which I outlined when I sat here on this chair, that our ultimate aim is to get people or to get the land back to the people.
Okay.
That is the main vision,
and
which we must all aim to that vision.
Last, I'm sorry to, rather than, I understand the political rhetorics that we have introduced in your plan, which was more or less the political rhetoric. The pertinent question to you, as I understand, was simply that, what is the plan? We understand that black people were dispossessed. We understand, we've read all the cases that we have referred to, the statement in that case. This is exactly what we want to hear from you. What do you intend? What do you think the court can do as an intervention? That is the plan that we want. But I could not understand what is that is, in that plan you outlined, this is a challenge for this court. And then in respect of this challenge, this is what the court is not doing today. And this is the intervention that I propose. But you don't do that. All what you do, you give us the political rhetoric, which we all understand and we agree with you. Every South African does. But we want the legal solution. We are a judge, not a politician. That one you leave to Commissioner Malema. He's going to deal with those.
I talked about the accessibility of the court to the people. And I said, to address that problem, is that we should take the court to the people. I said, we should work with decentralization of the court. I said, we must try and place judges at their provinces so that they can work from their provinces so that we do not incur traveling cost, we do not incur accommodation cost, because people are waking up from their homes and go to the people. And I said, with regard to missing claims, in the Eastern Cape, they've come up with the project of introducing this mobile bus office. And I said, maybe we should also get one of our staff, maybe it can be a researcher, who can also go with them in order to find and get the people who lodge their claims, but who are not following up on their claims. That's what I said.
Thank you. I don't want you to repeat what I mean. I understand. I was just pointing out what the Chief Justice. I think that can conclude.
Thank you, Chief Justice. Good afternoon, Judge Ngube.
Good afternoon.
Mine is just a simple one. As you know that the Land Claims Court is involving a lot of stakeholders now. One of them is training legal practitioners into actually, especially young ones, to go into the communities and gather evidence. The only concern that I have, I just want to hear from you. Most people have passed on because this project took too long. How do you think we can revive that type of evidence and make sure that is presented before court? Thank you.
Most people have passed on, the people who lodged claims. Yes. Well, I think the solution is that hearsay evidence is admissible in our court. If people have passed on and there's a person who can talk to that claim, there's a person who knows about that claim, even if he says, I heard from my grandfather, that is acceptable, that is admissible, we can accept that.
Okay, thank you.
Thank you, Commissioner. I don't see any further hands. Commissioner Marumachai, any questions for the candidate?
Thank you very much, CJ. I do have one question.
Please pose it.
Good afternoon, Judge.
Good afternoon, sir.
Thank you. My question goes into the philosophy that you apply, and in particular the theory of roles that you say that you subscribe to. And let me just say this before I pose the question, because my understanding of this veil of ignorance that assumes that people are purely rational beings who prioritize fairness and equality when designing a society. But my understanding of this theory is that it focuses on individual rights and liberties and potentially overlooking the importance of group rights and collective interests. On that basis, I just want to ask you how your adherence to this particular veil of ignorance theory is in line with the constitutional dictate of substantive equality, particularly in land matters. Because it seems to me that when one looks at the criticisms that have been laid against this theory, it seems to be running contrary to the constitutional project as we understand them. That becomes my concern, particularly in land matters. Are you committed to this kind of theory, or it was just a way of explaining a particular point at a particular context? Thank you very much, CJ.
Well, I don't think we can divorce the constitutional equality. I don't think we can divorce it from this theory, because it talks about one and the same thing, actually. The theory is about fairness and justice. Equality is about fairness and justice. I can't see the difference. It is the same thing.
Can I assist Judge Bethany to contextualize my question?
Yes.
Our Section 9 of our Constitution does not deal with equality. It recognizes different forms of equality. You have formal equality and you have substantive equality. And over the years, we have been shown that what formal equality and the dangers of formal equality. And I think that's what Rawls is actually propagating. What I'm asking you is, or first let me ask you, do you understand the difference between formal equality and substantive equality? And particular in land matters and land issues, because the communities that are experiencing land disposition and all those kind of things, and we are dealing with access to resources, we are dealing with regaining back, restitution, and all those kind of things. And obviously they want to get to a particular point in order for them to be given that which is theirs or that which they claim to be theirs. So I'm particularly concerned whether one, you really understand the concept of veil of ignorance as you are using it, and to what extent that is in line with the constitutional mandate as it has been explained by the Constitutional Court in so many judgments of the concept of substantive equality. Thank you very much, Judge.
Well, land dispossession was based on race. When I said proceed from behind the veil of ignorance, I said you must be ignorant of your race. When you distribute land, you must be ignorant of your race. You mustn't say I distribute land to whites only and not to blacks. If you give land as a grant, you must give land to everybody because everybody is treated equally. You mustn't say, I'm giving land as a grant to the white man and not to the black man.
Sorry, Chief Justice, can I just follow this up? I mean, it's a fundamental, forget about Rawls and veil of ignorance. I mean, it's a very complicated thing. Rawls was writing in the 80s, he was writing for the American society. He was not writing for the South African society that's engaged with the problem of apartheid. Just on the basic level, so that we all understand you, it seems illogical to me that you can say in a land reform context, we must be ignorant of the race of the recipients of land. The land reform project is in order to restore land that was taken by whites from black people. So just discount Rawls from the discussion and just face what has to happen. You want to be the second most important judge in land matters, but you say you want to be ignorant about who the beneficiaries of land are. I mean, that's completely illogical to me.
No, now I'm talking about restitution, not land distribution.
No, I'm talking about land distribution. I'm not talking about restitution. I'm talking about distribution. I'm saying the priority for distribution are African people. Yes. You have to know their race.
Yes.
What you are saying doesn't make sense to me.
Yes, what I'm saying is that what I was referring to, I was referring to restitution, but not distribution. But I agree that
but even if you talk about restitution, it's black people that were dispossessed of land.
I can't say the difference now. It's the people who were dispossessed, yes. And in actual fact, my answer was with regard to JP Mlambo's philosophy, leadership philosophy. It was not with regard to restitution.
Thank you, Chief Justice.
Follow up, CJ.
Yes, Commissioner.
Yes, Judge, when it comes to land question, because you call it on many other fronts and concepts, it's unnecessary, it's a land question. In the South African context, there is in no way, even in the application of any progressive philosophy, you can't consider the issue of race. Yes. When you deal with the land question in South Africa. And therefore to say, to ignore the race when you deal with land reinstitution or redistribution, that will be disingenuous. So do you agree that when it comes to the land question, in the South African context, race matters?
Yes, it does.
Thank you.
Can I thank Commissioner Malema? Can I just thank Commissioner Malema to, he got the answer quicker than I did.
Indeed. We can learn a lot from him, it seems. I don't see any more hands. We've reached the end of your interview, Judge Ngombe.
Thank you.
Thank you very much for making yourself available for this vacancy.
Thank you for inviting me.
You're excused.
Thank you.
Sorry, shall we clear the room then? Oh, I was proposing that we go straight into deliberations, then take lunch thereafter, a short lunch.